Good morning. Good morning. It's Tuesday. It's February 13th. I'm back, sort of, meaning I'm back, but I'm still feeling special. I missed you guys last week. It was a rough week being sick all week, but I was sick all week. But there's a lot of things we need to catch up on, not just in what's going on with me, but also in like all of the cases that we're covering. We're going to take it a bit slow this week just because my brain is still not 100% online. So I'm going to tell you what we're doing today. We're going to roll the intro. We've got a bunch to talk about. We're going to be streaming tomorrow unless the hearing in New Mexico gets bumped. So we've got a busy week for you too here because there's a lot going on as we get closer to Hannah Gutierrez Reed going to trial. So let me tell you what I've got on the docket for today, and then we will start rolling into things. So Lana, it's good to see you. Hope you're well. Hope you're better. Hope your tummies are doing better than mine. All right, let's see. Today we've got some updates in Idaho, both in the Idaho University murders case and the TikToker responded in the TikTok defamation suit. We need to look. When we're looking at legal analysis, the low lift on legal analysis is pro per filings, and we're doing that. We're doing that today because I haven't read them yet, and I've been dying to read them. So we're going through the TikTok psychic's response to the last motions from the professor. We're doing that. We've got updates on the texting judge with a stipulated settlement. Gee, shocking. Nobody saw that coming. Everyone saw that coming. Donna Adelson was back in court to set a trial date. We're covering that. And then I've got some updates. You might have seen me on your Hulus. You might have seen me in YouTube's newsletter for 2024. We're going to talk a little bit about those things too. Replay crew, love you. Everything will be timestamped down below. And then we are working on app notifications. Don't know why they didn't go out when they were supposed to, but we're still working on that with everything we build. Sometimes we break. And then we've got a whole bunch of stuff that's just getting backlogged in the docket of stuff I want to talk about. So hopefully that's what we'll get to on Thursday. Tomorrow, there is a new Emily Show podcast that'll drop after, well, no, I can't say that. I'm not sure when it'll drop. I have to look at what time court is tomorrow. I haven't planned my calendar that far in advance yet. Because yesterday was a minimal work day for me. But I'm covering the appeal in the Amber Heard insurance case to talk about what's going on between Amber Heard and New York Marine and all the rest of it. So that's all the things. All right. Let's get into it. Let me know where you're coming in from and what you're drinking. I've got my Lunar New Year of the Dragon mug. It is also, I saw some of you wishing happy birthday to G. Thank you. He is a Year of the Dragon kiddo. He is a 2012 kiddo. So he just celebrated his birthday, but I've got my coffee in here. So let me know what you're drinking. And let's roll the intro. Let's try to remember how to stream. We're professionals here, right? It's gonna be fine. The biggest fail I might have made for my streaming setup is I put a new bird feeder outside of my office, and it's glorious. Like the amount of songbirds that we have where I am in Middle Tennessee is just so great. They're delightful. I love them. I love this bird feeder. I love everything about it. My cats are obsessed, and sometimes that goes sideways. Yesterday, all of the waters, there was a juvenile cardinal who was taunting George. All of the waters got knocked over on my desk. So it's the cats are so enthralled, and I'm now also distracted. It's like not squirrel, but like right now woodpecker. That's just what's going on. So the cats are in heaven. So now I need a cat cam. Now there's like reason to have a cat cam because the cat cam will have them in one place looking at the birds. We need some kind of cat cam that will also get the songbirds. So we have all of it. And I can do that over here because it's easier. Anyway, so they are in heaven. I am distracted. We're going to roll this intro and hope that it's the right one. So cheers, law nerds. Let's roll.
Hey there. I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
We had snow last night. It was so funny. It was like 60 degrees, 50, 60 degrees yesterday, and then raining. And then last night, there were odd shadows going across the frosted window in my bathroom. And I was like, that's strange. And then I was like, that can't be snow. And I popped my head over to the window, and giant, fluffy, wet masses of snow. It was it was just wild. It was just wild. Members only shouldn't be on in the chat, but if it is, we'll make sure it gets turned off. So if it is, that is on the back end, but it looks like it actually might be. So thank you for the super chat. I appreciate it. We fixed it. I see it just getting fixed. Thank you. Thank you. Thank you. Thank you. Auntie Candy, thank you. it's not supposed to be. That was just us forgetting to do the things because the app wasn't working. So it's okay. We have all the things. Hi everybody. Look, we take a week. We're under the weather and things the wheels just come off. All right. That's why. So for those of you that were waiting to chat, apologies. This is my first non-gifted membership month in a while. Allison King, don't worry about it. Hopefully it'll get caught up. I've already seen some gifted memberships in the chat and lots of member chats because you guys didn't get to do them last year. And we just got the app notification. Good. It's like, it's 11:11. It feels like this is our normal starting time anyway. So it's just, everything's running on Emily time today, including Emily. So it's perfect. Sarah said, hey, from sunny Kentucky, the winter storm warning we had last night didn't amount to anything. Hope you're having a good day. Absolutely having a good day here in Middle Tennessee. We got a little bit of snow. It was lovely. It was like cute snow. Like this morning we woke up and we're like, oh, it's snowing. And then by like 9 a.m. it all melted. Like it was adorable. That's my favorite kind of snow. Not like, oh my God, we're snowed in for a week. Though sometimes I love that too. Let's talk about some of the wins. I don't always talk about wins with stuff, and I'm going to start sharing because I feel like they're not Emily wins. They're like Lawnerd wins. They're like all of us. And when the Lawnerd community gets acknowledged, I think that's a really special thing. And I really want to take a minute, to thank all of you because truly, I mean, I know you guys hear people say it. Entertainers say it, singers say it, YouTubers say it, podcasters say it, but it really is true that I get to do what I do because all of you also enjoy what I do. That's the coolest thing ever. It's not because there's nothing else to watch. It's not because I'm on one of the 4 networks that exist. It's because you choose to spend your time here with this community and with me, and that is never lost on me, and it always blows me away. And so there's times when I'm like, there's things that I want to share and I'm like, well, I don't know. Does anybody care? And I'm like, you know what? This year we're sharing. This is the year we're sharing. We're going to assume everybody cares and we're just going to share. So the Lawnerd community and myself was featured in the letter from the CEO of YouTube that came out last week while I was sick. It was released February 6th. I had planned to share it when I was streaming that day, wasn't streaming, totally sick. But was really excited. If you guys are and do love this platform, go ahead and take a look at kind of the direction of the platform. But one of the things that was really wild to me is this statistic here that they started out with, that the YouTube Partner Program pays out more than any other creator monetization platform and has paid over $70 billion to creators, artists, and media companies over the last 3 years. Because it's not just streamers like me that get paid on YouTube, right? Musicians get paid on YouTube. Companies that stream on YouTube get paid on YouTube. It's insane. So I love seeing a platform, though not perfect. I'm never going to sit here and be like, any of these platforms are perfect. I don't know how you can be perfect as a massive platform, but I always get the sense that YouTube is trying to do right by the community that's on this platform, by the audience that watches and the creators that create on the platform. That is always the sense I have gotten since I joined as a creator in 2016. But since I started watching YouTube in 2006, look, man, we would get back from court at the DA's office and somebody would be like, oh my God, did you see this thing on YouTube? And it would be like, what did the fox say? And I'm like, this is delightful. Like there is a connectedness to the pop culture things that happen on YouTube. But I think the fact that in a time where we're seeing other platforms, TikTok, Instagram, where we're seeing other platforms struggle to figure out if they are even paying creators, if they are paying creators, and how much they are paying creators. No one is paying creators what YouTube is paying creators. That is facts. $70 billion to creators, artists, and media companies is a staggering number. That money has absolutely changed my life and so many other creators' lives. But that changed my life when my channel was at like 20,000 subscribers. It's wild and I love it's wild and I love it. So this platform I love because I think it does so much good and no other platform has really caught up to this. And I don't know if they want to, right? Like TikTok, it doesn't even want to pay the musicians that drives the music that drives the platform. I was looking at a friend who shared the back end of their analytics on TikTok. They had like 14 plus million views in the month and got like $3. Mm-hmm. Mm-hmm. Scandalous. Just scandalous. So YouTube is disclosing how much they're paying to again remind people that they are the platform that pays. They are also fighting for creators to be viewed as next generation studios, like for creators to be treated on the same level as media. Creators are driving media. And with that, it's so funny because I did an article that'll come out at some point. Who knows if they love my input to this article, but I did an article that'll come out at some point and I'll share it with you. And the reporter that was doing it really wanted to know how much I make on this platform. I get asked this all the time, not just by other creators and by other creators that are having like a one-to-one conversation like, hey, are we all getting hosed on brand deals or are we all kind of doing about the same thing? Like we absolutely have those conversations. But for people who are like, how much money are you making a month? I'm like, it's not that simple of an answer because I have a team. I'm not just sitting down and streaming. Miguelina, my producer, who also does editing, is on my team. I have other full-time employees, W-2 employees on my team, contractors on my team. Like I'm running a company. So how much money I make a month is also is not exactly how much money I make a month because there's a lot of overhead. So like, are we talking gross? Are we talking net? It's too funny because they're like, well, how much money are you making? I'm like, why does it matter? Like also not the measure of success that I really care about. Like the measure of success for me is that we have tens of thousands and sometimes hundreds of thousands of people having conversations about the law and having conversations and understanding these court cases and being able to have sometimes sassier than other times conversations about cases without attacking people. Like you can build a positive community on the internet where people come away feeling like they've had a chat with their friends at the end of the day. And isn't that a much better measure of success than how much money you may or may not get paid a month? So anyway, I don't disclose how much I make because again, you would need to get into my taxes because how much I make, not actually how much I make. How much money goes into the company and how much money comes out at the end. There's a whole lot of stuff in between there with overhead and payroll and merch and taxes and all the rest of it. So what I always tell people is I make enough to be a full-time creator and I'm blessed to be so. Blessed to be so. So this goes on to say, creators are truly entrepreneurs and we're helping them diversify the ways they make money on YouTube. We're investing in ways creators earn money while helping viewers shop for products, and viewers are directly supporting their favorite creators through fan funding features like channel memberships. Y'all, the channel memberships are a game changer. Also, I think, don't tell legacy media this, I think they're jealous because they all try to do fan funding, right? Like they're all like, pay our subscription fee and then we'll show you articles or whatever. And sometimes people do that and sometimes people don't. But like, I think they're a little jealous that creators are able to really build a business on fan funding where they're not able to really crack that code. So it says the number of creators using memberships increased more than 50% last year. That I hope is due no small part to me screaming at every creator I know with love that they need to lean into their community and turn on memberships. I'm like, just talk to your people and have the most fun. Just go talk to your community and have the most fun. So they say, like Naray Consulting, who leaned into membership to draw more viewers to her career development content, and Emily D. Baker, hi, it's me, whose membership earnings grew more than 50% last year. The majority of Emily's YouTube revenue now comes from memberships. It does. The majority of our revenue comes from memberships and fan funding, because half the time I don't even turn on ads because we don't have to, because we get to cover what we want to cover. We get to cover all the things we want to cover. And YouTube is making it better for us as creators to do that. And it's incredible. So, Fat Fierce and Over 50 Elizabeth said, you got me to realize law is fascinating following since Toddy. Thank you. Thank you. Totally jealous. I never watch regular TV anymore. See, because we're here. We're here. So I'm going to start asking, because I saw you guys in the chat, to just start asking Legacy Media, how much do they make? Like, how much do you make? Monuments of Speculation said income transparency is an interesting discussion. I saw a tech lady on TikTok was fired for disclosing her salary and a $20K raise. I can see where that's problematic, though. Oh, some companies have like NDAs over disclosing how much they're making. And it's interesting because on YouTube, it's always different. Like, everyone can set their memberships at different rates. Super chats go in certain blocks, but the difference with super chats, and this is why it's hard to always nail down a number, super chats, depending on what device you put a super chat through on, there's a portion that gets taken by the platform. If it's on Apple, then a percentage that goes to YouTube and a percentage that comes from me. And as long as my accountants aren't screaming at me that I'm not going to be able to pay payroll, I generally roll with it's fine, we're good. So somebody asked she also asked, what was the percentage of revenue I make from the merchandise shop versus memberships versus like ad revenue? And I'm like, I don't know. Like, I would actually have to go to like my profit and loss statement and ask somebody to run those numbers. Like, I'm not guided by that. So it's just so funny when people try to use how much you make as a metric of success. I don't know. Like, Mr. Beast makes a couple $1 million a month, but he also spends a couple $1 million making his videos. Like, is viewing, I don't know. I hate using money to measure people's success, because I don't think people that make more money are necessarily good people or necessarily bringing something better to the world. I don't think it puts you, I mean, it definitely makes life easier, but I don't think it makes you better. I fucking hate it as a metric of success, truly. And I was like, there's a lot of metrics of success, I think, that we can look at, and positive impact is one of those success. And we've made a lot of positive impact here. So I think that's successful. Look, man, we have a positive community. And I think that is a massive metric of success. And I get to make a living doing what I love with a bunch of nerds that love the stuff that we do. So thank you. Thank you. And the fact that the CEO of YouTube included me in the letter, not only that, like linked the channel and everything, like, I'm just blown away. I'm just absolutely blown away, because we decided to do it different. And I said, hey, we're going to do this different. And all of you said, abso-fucking-lutely, let's do it different. And thank you for that. Speaking of which, we're also on Hulu. So if you have Hulu and you watch Hulu, the Housewife and The Hustler is now live on Hulu. I put up a short on the Shorts channel for you to go see it if you want to go see the shorts. Oh, do I have to? I can't just show you. Hold on. I've got to log into my Hulu on the computer to show you. Okay, computer. Yes. But the Housewife and The Hustler is on Hulu. Let's see where it is. I'm going to go find it so you guys can see it. But I was really happy to take part in another production with Hulu and ABC Studios. It is interesting because it is the first time that we're seeing some of the footage of Erica Girardi sitting down with victims of her husband. So if you are on Hulu, The Housewife and The Hustler is there. I am in it quite a bit, more so in the second half. Here's what I loved about it. And so you guys can choose if it's something that you want to watch or not. But here's what I love about it. They really leaned into talking to Harriet Ryan and Matt Hamilton, the two investigative journalists from the LA Times. I love the work that they have done on this case. They and the LA Times have been tenacious in digging into Tom Girardi. The LA Times sued the State Bar of California to get all those to get all the reports released about what was going on with how many investigations Tom Girardi had against him. And they were really leading that charge in a way that an entity like the LA Times can, in getting it taken seriously when they actually sue the State Bar of California. It was fascinating. Also, after the first article dropped, and that first LA Times article was just like a what kind of an article, and then we saw the housewives like reading it on the show. What season? Last season, the season before, when this massive expose drops, that all the housewives are like, what? And Sutton reads it, and the other ladies are like, TLDR, please. But it was really fascinating to hear not just that Tom Girardi called the LA Times and demanded a retraction, but to hear the voicemail that Tom Girardi left for Matt Hamilton, like threatening legal action after it came out. So I was absolutely blown away by it. So that's what's going on with The Housewife and The Hustler. You'll recognize if you do a lot of stuff in the Bravo sphere, you'll recognize the ladies from the Bravo Docket podcast, Kiki Monique from Talk of Shame. You'll see Kate Casey from Reality Life with Kate Casey. Like, you'll see a lot of people in there, but the behind the scenes with Erica sitting down with the victims was illuminating on Erica's ability to process and understand what empathy actually is. So that's interesting. Our Hampy, they did on the last season. There aren't any housewives on this one. So I don't know if Hulu gives you a like sign up trial situation. I wish they gave me one that I could give out to y'all. But it's fun. My legal commentary, my TV voice is there. I saw some of you being like, Emily, I'm very put off because you have legs and you're like sitting in a chair and I only see you from like here up, and it's very strange seeing you in a different room, in a different setting with different lighting. I know. Every time I go to do one of these things, the way I fight with them over where they place the cameras, they look, when you're sitting down to record these things, like half your face is lit. And then my camera right now is up here. When they film for TV, they put the camera down there. And I'm like, why? Why are you down there? Like, there's nothing good is happening if you're shooting me this way. Like, what are we doing? My face does not do this. We need to, like, selfie angles. Why are we not shooting me from here? Every single time. They know now. They know now that I'm going to fuss with them over how low the cameras are. I'm like, at least we could go dead on, please. What are you doing? Emily's wearing pajama pants right now. I mean, basically. I hate it so much. I'm like, can you just, this is the part of me that we show. Can we just do it? Can us UK people watch? Lauren M asked. I don't know why you wouldn't be able to, but I don't know if ABC News is location locked. I truly don't know. I can reach out and ask. So, you looked fabulous. The camera angles are weird on documentaries. They're so weird. Pinky Mingo, and I hate them. I'm like, look, media, can we just start shooting everything like a YouTube video? Please and thank you. It would make me much more comfortable. Let's go to quick bits a little bit. It's so good to see so many of you guys enjoying it. So thank you to everybody that reached out and was like, hey, I saw you on Hulu. I got a number of those texts yesterday. It's always fun to take part in projects where I'm excited to see the project itself and B, the other people involved in the project. I really was very curious to see that footage of Erica. And you guys can make your own determination about when somebody's like, I don't understand why they're all mad. it was interesting to see. Oh, and Erica's lawyer is in this too. So Erica's lawyer in the bankruptcy is on camera, and her benefactor. Like there's tea. There's tea like sprinkled throughout this documentary. So if you're interested, go check it out. Anne Marie, I can't get my hopes up on Dave Matthews being up for the Rock and Roll Hall of Fame again, because they keep breaking my heart. So, we can't do it. We can't do it. I don't know where else to watch it other than Hulu, because it's a Hulu ABC production. So I don't know if it's going to end up being anywhere else. All right, let's go to quick bits real quick, and then we're going to go to Donna Adelson in court. Sound good? Yep, we're going to caffeinate our way through today. It's just, Emily, where's your quick bits bumper? We've got it. I swear. Quick bits. So we've got a real quick bit coming out of Idaho. This one's actually quick. They've set a new hearing. You know how we're going to do these hearings. We've learned from last time. We've got a backup process now for the hearing in Idaho. So in the Idaho murder case, they have set a new court date and a new hearing based on defendant's motion to allow certain experts and investigators protected access to view IgG material. This is over the DNA. Defendant's motion requesting clarification of the sealed order for disclosure of the IgG info and protective order, and the state's request for scheduling order. The court orders the following. 1, a hearing on the motions is set for February 28th, 2024 at 1 p.m. Pacific time. This hearing will be open to the public and will be live streamed on the court's YouTube channel. As to scheduling, counsel should be prepared to address scheduling, both a briefing schedule and oral argument on defendant's motion for change of venue, a discovery cutoff deadline, expert disclosure deadlines for pre-trial motions, and such as motions to suppress or motions in limine, and dates for a trial. I'm covering it. They might talk about the IgG a little bit, but the scheduling order is really what I'm invested in. So we'll be covering that live. I think that's a Tuesday. If it is, it means our normal stream time will bump back to accommodate this. And we've learned from last time that we can't pause the feed, because the second that they're done in court, they set that video right to private. Like, whoop. It's absolutely wild. So we're going to be covering that. I'm interested to see if they set a trial date. We're seeing it's probably going to be summer of 2025. But we'll get an idea of what they think is going on, how many witnesses, the motion for the change of venue, and all. I want to hear the motion on the change of venue. I think it's a bit premature. So yes, mark your calendars. We're doing that. February 28th, we'll be back in Idaho for that court date. All right. Next quick bit. We're going to talk about this texty judge. Oh, Your Honor. Oh boy. Let's talk about texting judge.
For those of you that don't remember, we are gathered here today to talk about why you don't talk shit via text at work when you're the judge presiding over the homicide of a child trial. And don't objectify your law enforcement officers. Don't throw everybody in the courthouse under the bus. Don't go on Facebook and be like, lol, I insulted a bunch of gang members today, getting greenlit. Quirky.
Like, no, stop texting judge. Stop texting judge. Texting judge was judge for 10 months when they speed ran the end and demise of their career. Texting judge is 50 years old. And I only say that because, like, old enough to know better, but not so old that you just don't give any of the fucks. 10 months, was on the bench for 10 months when the most ridiculous and thorough disciplinary action we have ever seen came to the attention of the media. If you have not listened to those episodes, A, they're on the podcast if you want to listen in the background. B, they're up here on the YouTube channel. We went through all of it and the responses, and a lot of the responses were like, I mean, yeah, but like this person did this and that person did that. They settled. They came to a settlement. This was getting ready to go to trial, the disciplinary action. They were asking that texting judge get yeeted. They settled. We're going to read the settlement together. I'm sure some of you have seen the headlines. No spoilers. Final order. A settlement stipulation was filed in this case on February 8th, wherein the duly appointed counsel for petitioner, the respondent, Tracy Sonderstrom, whatever.
Tracy with an I with a heart on the I. Tracy with an I. Yeah.
Tracy and respondents' counsel reached an agreement as to all issues pending. The Court on the Judiciary Trial Division met on February 8th. The Court on the Judiciary Trial Division found the settlement stipulation to have been made knowingly and voluntarily by all parties and accepted the same. Based on the stipulation of the parties and based on the law and the evidence, the Court on the Judiciary Trial Division finds and orders as follows. The respondent, Tracy with an I, shall immediately resign from the office of District Judge for the 23rd Judicial District of Oklahoma. Her resignation shall be irrevocable and shall become effective on Friday, February 9th at 5 p.m. She shall immediately transmit a copy of her resignation to Jerry Askins, Administrative Director of the courts, and to the Honorable Lee Turner, Presiding Judge for the North Central Judicial Administrative District. You will resign. Yeah, you guys are like, the judge resigned. The judge resigned because the judge was getting yeeted. Like, the only reason that this was like a, you can't fire me, I quit. The only reason this judge resigned is to maybe save the embarrassment or penalties or fines because of this. Respondent shall not seek or accept any judicial position in the state of Oklahoma. The Court on the Judiciary shall have continuing jurisdiction to enforce the order. Cannot be a judge, cannot run for judge again. Not disbarred, but they gave her the option of the dignity of choosing to leave. This is not a disbarment. This is get the fuck off the bench and never, ever getting back on the bench again. Ever. They don't say anything in here about their retirement, but I imagine that with less than a year on the bench, her retirement didn't even vest, so that's probably not a problem. Could someone choose to bring actions to the state bar and see if she's going to be disbarred? I'm sure they could. Could she go to another state? I mean, Minnie, I don't think she would be considered adequately in good standing to become a member of the bar in another state at this point. So could she go back to lawyering at this point? Yes. Could there be disciplinary actions brought up there? Yes. Amy said, you can leave or we can escort you out. Choice is yours. And she's like, yep, I'll leave. Caitlin said, would disbarment be a separate action? It would have to be. It would have to be a separate action. This is not happening with the state bar. This is happening with the Judicial Council. There is a council that oversees judges and a council that oversees lawyers. The Judge Council can't disbar her. They can remove her from the bench and prevent her from ever holding office again as a judge, and they've done that, but they can't disbar her. So could there be disbarment proceedings? Sure. She was texting. It goes so much deeper than that. There was texting, there was sexual harassment, there was objectifying, there was lying, there was so much more than just texting. But texting judge became the shorthand because that was the headlines, because she was texting over 500 times during the murder of a child trial. And this is when she was brand new on the bench. The thing you need to do as a bench officer is like, pay attention, because when there's an objection, you need to have the recall memory of what just happened to rule on it. There was so much inappropriateness. So much. She was not limited to texting, but the 500 texts during a murder trial were shocking. Texting on the bench is shocking. And this is not like texting on the bench during a break, like leaving in 30, I'll pick up dinner. This was making fun of the litigants, the participants, making fun of the lawyers, rooting for one of the lawyers, deciding on guilt versus innocence, objectifying law enforcement officers. Not that Emily, have you ever seen a judge directly objectify law enforcement officers from the bench? Yep. Generally female judges. I get it. Some cops are hot. I get it. I get it. But they're like, they're at work. Let's not objectify people at work, even when they're hot. Like, Your Honor, let's do better. Let's maybe do better. Oh, so I've never seen anything quite like this. Do I believe it all happened? Absolutely, absolutely. I've absolutely seen judges do some shocking shit. I've absolutely seen judges do some shocking shit. So much sexual harassment. And what's funny to me is I think, I guess it's not funny. What stands out to me, funny is the wrong word. What stands out to me is that there are times I think women, especially as they are, into their 40s and 50s, I think some are like, it's cute. Like, what? I'm just telling him he's handsome. It's like, no, ma'am, no. It's uncomfortable and it's weird. And you're in a position of power and it's weird. And it's weird. Stop it. Stop it. Just let's not objectify people at work. Not cute. Not cute at all. Let's just do that. Let's just do that. Why is that hard? And again, I think there would be a lot more outrage. I think there's still more outrage when men do this than when women do this. But if a male judge was like, hey, cute female attorney, get in this chair and take pictures with me, I think the headlines would have focused on that and not the texting, right? It would have been like, it would have focused on the sexual harassment. It didn't focus on the sexual harassment. And sometimes women offenders get a little bit more leeway on that because people are like, oh, it's just harmless. No, making people uncomfortable at work is not harmless. Don't do that. It's not cute. Objectifying people doesn't make it all right. Like, let's just let it go. Look, people are allowed to like have a face and a job. Weird. Sometimes they have a body and a job. I know it's hard. I get it. Just don't do that. What happened to the bailiff? Don't know. I want to know if the bailiff got terminated. I'm sure the bailiff got moved, but I don't know. No one said, yeah, Lizzo's dance captain. Exactly. And then when you've got same gender harassment, it's still uncomfortable. Just stop it. Just don't do that. Don't do that. And maybe, just maybe, law enforcement agencies, don't cast all of your officers out of central casting. Some of them are uncomfortably attractive and people can't do their jobs when they're all like hot and in uniform and stuff. Just saying. Just saying. Sometimes it makes it hard. People are like, don't be hot and work. It's like, go model. I'm teasing. Don't objectify people at work. That's it. That's all. People objectify themselves enough on social media. Like, you don't need to go to work to objectify people. I know, Manders. I know I just proved my own point. I was trying to be funny. So, but I did spend a lot of time working with a law enforcement. One particular stood out I worked with lots of law enforcement agencies. There was one that looked like they went to Abercrombie and Fitch and were like, you're over 6'2". You're very attractive. Would you like to join our fine police department? Because it looked like they basically just hired everybody that worked at Abercrombie and Fitch. It was very off-putting as a new DA. It was like, what is happening? Like, what? And then I would work with other DAs. I'm like, so this. And they're like, that. And I'm like, but, and they're like, yeah, no, that. And I'm like, but, and they're like, no, yeah, that. I was like, okay. We're just, all right. It's funny because I had a coworker, the coworker I've told the story about the blue smoothie ending up all over his shirt and him being like, I can't go into trial looking like I've murdered a Smurf. That coworker, when there were times people would be like, hey, how's your day going? And he's like, I can't stand you talking to me like that. I'm married. And would like hold up the ring finger and just be like, you just can't like talk to me like that. It was so, every single time, it always caught me off guard. It's like, hey, what are you doing for lunch today? I'm married for lunch today. That's what I'm doing for lunch today. It's like, okay. Always funny. Every single time funny. So, all right, let's continue. Let's continue. I also had a coworker at that particular office that had a rule of 3 for lunch and was like, nothing good happens if there's more than 3 people. So, I've already got 2. So for lunch today, like we've already got 2. We've already got 2. So rule of 3. I was like, that's a strange rule. All right, let's keep going. Yes, I'm married for lunch today. We used to, same coworker that would be like, but do you guys want to go to Hooters though? Because wings. It's like, no, I'm married for lunch today. I don't want to go to Hooters and get wings. Actually, I rarely said no to going to Hooters and getting wings. Wings for lunch are always a delight. All right. Let's see. Where are we? Idaho updates, texting judge updates. I'm on Hulu. I'm in the letter from YouTube. I don't know what my life is. I love the law nerds. I feel like that summarizes quick bits. Should we just go to Donna in court? Should we go see what Donna's up to? Wings are a great lunch, by the way. Hands down, always a great lunch. I was so thankful because I had a coworker that was like my lunch buddy when I was a new DA. And I always try to accommodate other people's hyperfixation meals because I understand what that is like. And I get it when like this is what you eat for lunch every single day. But there was a period of time where this coworker was just like Jamba Juice for lunch. And I'm like, a smoothie's not going to do it. I can't do smoothies every day for lunch. I can't do smoothies every day for lunch. Like, I love you. I want to go to lunch. I enjoy our chats. We always have good music in the car. But I cannot do smoothies for lunch every day. Like, go get your hyperfixation. I can't do it. Though there was a restaurant in Long Beach that every day when I was pregnant, my coworkers are like, what are we doing for lunch? I'm like, Mexican food. Like, yes, we are. I'm like, every day, same order. That's all we're doing. All right, let's go to Donna. Donna's in court. Donna was in court yesterday. For those of you that are new to the Donna Adelson case, she is in court for a case management conference. She is setting a trial date. We learned some more information that's going to be very, very interesting to me. Donna Adelson is going to be standing trial for conspiracy to commit murder, solicitation of murder, all the things, because they are alleging, was an instrumental part in her son hiring the hitmen and middle person to kill her son-in-law. The argument is that the son-in-law was trying to restrict her access to the grandkids while the son-in-law and the daughter, Wendy, were divorcing, and that Donna became obsessed with getting her way, moving the kids out of Tallahassee, Florida, back down to the other end of the state, closer to Miami. And that after he had won, the victim, Dan Markell, had won those hearings, and it looked like the grandkids weren't going to be able to like go live in Miami and were going to stay closer to their dad in Tallahassee, that she was the one really pushing ahead, that something needed to happen to end all of this. And before the hearing that would have limited her access to the children because she was disparaging their father when they saw her, he ended up dead. So she's going to trial for that. She's back in court. If you haven't, the most illuminating things about Donna that I have covered really are those jail calls, and then the video of her getting arrested at the airport where she's like, no, I don't want to give you my phone. She's just like, no, you're not taking my phone. And they're like, ma'am, you're being arrested for murder. This is evidence. Give up your phone. She's a fascinating bird. So we're gonna hop on over to this footage brought to us from Law and Crime and see what Donna has to say, shall we? I think the volume's turned up pretty well. It's a pretty short hearing, case management conference. She appears via Zoom.
Ms. Adelson, can you hear?
Did I swoop? Hold on. Let me swoop a doop once more. I think I swooped, but then I soliloquied. Let's swoop again, just in case.
Ms. Adelson, can you hear me?
Yes, I can, Judge.
All right. Good afternoon. Let's go ahead and address next State versus Donna Adelson, 2023, CF 3226.
Judge Alex Morris and Dan Rashbaum on behalf of Ms. Adelson. We're ready to ask the court for a trial date.
Right, Ms. Dugan. you
Ready
can
to
make
ask
your
the court for a trial date. I'm going to turn this up just a little bit more. I'm excited to hear what their trial date is. So everybody get ready to mark your calendars. Away we go.
This is Sarah Catherine Dugan for the state.
That's still really low. Let's just, Emily, just go. Full tilt, full volume.
September trial date with the defense, and I think we all agree to those dates, and have kind of looked at the calendar for that time, looked at the court's trial weeks and a possible fifth week.
They say September trial date. Not only the same judge as Charlie's trial, because Charlie, the son, has already gone to trial. Same defense lawyers as Charlie. Mm-hmm.
Week at the end of the week, and I think we're all flexible as to what will work for the court that month. We can make work for us.
Right, defense.
She got it right. Whichever way good.
Is that really the way we want to answer defense when the prosecution's like, this is the conversation, and they're like, she got it right? I'm not going to misrepresent shit to the court. What? Stop. Emily, you might be annoyed for no reason, maybe.
As to what will work for
I'm going to bump this volume up one last time. I don't know how much louder it can get, but that's as loud as we can go.
the court that month. We can make work for us.
Right, defense.
She got it right. Whichever way good. Looking at your calendar, that last week of September, the 5th week, and then spilling over into a natural trial week seemed appealing, but I don't know what your schedule allows for.
Right, well, this is somewhat difficult to say. Judge Allman still is in the process of determining who is going to be in what division. This case will stay with me, but if I'm otherwise in a civil division or doing something else, it probably becomes a little bit easier and more flexible.
They can move you from a criminal division to a civil division? The fuck? That would be, I can't think of anything worse for a judge to spend their time in criminal. And then this is why being a federal judge would suck, because you have to do both criminal and civil, and it's just so much more stuff to do. But if you are a criminal judge, to get shifted to civil, like, oh God, that would just, it would take all the information that's in your brain to run all of your criminal trials. Like, all your brain is full of all of your criminal stuff. And then it shifts into civil and you're like, fuck. It is a whole different situation. I love that this judge is like, I'm keeping it. I'm keeping this case no matter where I go, but oh, that would be awful. It's like watching criminal judges or judges that become judges. They get elected, they take the bench. They've worked in criminal for their entire careers, and then they get sat on the civil bench, and it's just like, they're like, what do you want me to do with this? I'm a criminal lawyer. It's so very different, criminal law and civil. It's just such a very different world for both lawyers and on the bench. So being a federal judge, they have to flex between the two. But criminal's such a confined universe. I mean, your big problems in criminal are going to be like 404s and hearsay, and your motions in limine are pretty limited because you're not dealing with really strange and unusual questions. I mean, the stuff that comes up is pretty much the same stuff that always comes up, and it's not really that weird. Oh, but civil, oh God, so strange.
To schedule the trial. But for now, let's operate as if I will still be in Division C. We'll put it on September. September 26th is the docket sounding you'd be asking for. That's the one before the
9/26 for docket sounding,
Yes.
which is
Ms. Dugan.
case management.
That'll be fine. We'd be fine with either the September 12th docket sounding or the 26th.
Actually, let's go ahead and put it on the 9/12 docket sounding. The idea being that the start of jury selection would be during that 5th week. But that should give us some time if there's anything that we need to work out ahead of time to deal with.
Because shit
before
comes
the trial
up.
starts. I am going to end up, now that we have a date picked for 9/12 being the docket sounding and the week of trial starting September 30th, probably going to end up entering a separate order that deals with a motion and discovery cutoff. So that way we're not dealing with these issues up to the wire. However, cases have a mind of their own.
They sure
the
do.
cutoff date will be in place. However, if we need to address it any further from there, we will. One matter that I did want to make sure we had a clear record on: has any plea offer been extended to the defense?
No, sir.
Does the state intend to give a plea offer?
Not that I know of, but if something changes, we'll let them know.
Very
So the judge wants to know, is this case going to plea? Is it not going to plea? Have you offered a plea? And the state's like, negative, ghostwriter. The pattern is full. In murder cases, you don't always get a plea offer. Could Donna Adelson plea open to the court? Yes. I mean, there's not a lot of room in the law on what to sentence her to. So I don't see her saying, Your Honor, we'd like to just plead guilty to the sheet. There's not a lot of wiggle room outside of like all of the prisons. So I don't think Donna's going to plea. I think it's going to have to go to trial, but the state is not offering anything. And why would they? They convicted Charlie. I think they are confident going forward to this. So no, they're not going to offer a plea deal. No, go to trial.
well. Has your client wanted to convey any offers to the state?
No.
And again, everyone knows me well.
This is just gonna go to trial.
Prodding
The judge
or
is like,
pushing
great,
about
just
plea offers or
push play, go to
state
trial.
making one.
Just
But
go to trial.
ultimately, when it comes down to it, if Ms. Adelson is to make a knowing, intelligent, and voluntary decision about going to trial, that includes whether or not there is any plea offer to reject or accept. If the state is going to make a plea offer, please notify the defense promptly. From there, if the defendant intends to reject it, she will do so. Are there any other matters that we need to address for today?
That's it, Judge.
Not from the state.
Very well.
And that's it.
Ms. Adelson, the next time we have a status date, you will be in the Zoom booth so you can see and hear what's going on, similar to today. Before we get to September, do you all wish to set a status in the summer?
Please.
Right, before July or after?
I'm going to ask for one in June, preferably, and then take another look at one in August or early September.
Well, you've got one in September. You've got one September 12th.
Then we'll go ahead and have a status hearing during my business week of July 22nd. We'll go ahead and put it at 1:30 in the afternoon. At that point, the order as to discovery cutoff, motion cutoff, and other pretrial matters that will already be in place, everyone will have your guidelines to operate from. There's nothing else to address from here. Ms. Adelson, that is going to conclude your case management hearing. Your attorneys will be in touch with you. Have a good afternoon.
And that's it. Not
For
much else to do.
everyone on Zoom, that concludes the hearing. I'm going to be logging out.
I love that the judge told them instead of just yeeted everybody into like oblivion. That's this case has been so just kind of by the book. Like it's just a very normal status hearing. We saw such long hearings in South Carolina. Everyone had a lot to say. This is much more a normal day in court on a status hearing. We need these dates. We need these cutoffs. We need a trial date. No offer. That's it. Moving on. So it's much more normal court procedure, what we're seeing in the Adelson case, than what we've seen in like the Murdaugh case. Those hearings were so much longer than necessarily what needs to be. This is just very, let's move it along. So she's set for trial in September, and that's what they're going to do. I imagine we'll see one or two hearings before then. I don't think we'll see many fights over discovery because there's not much to fight over. They've already done this trial with Charlie. They've tried the shooter. They've tried the go-between who kind of went between Charlie and the shooter. One of the other defendants pled. There's not a lot of complexity here to prepare for seeing how many times they've done this case. The only new information they're going to get is whatever they get from Donna Adelson's devices, and whether they bring additional charges with her trying to flee the country before she was charged. So we'll see. But it's not, there's not much to happen. It just go to trial. Like, just go to trial in September. So we're going to cover that. It is what it is. There's not much more. Angie Lewis says, what does docket sounding mean? They're just bringing the case into court to make sure it's ready for trial, to make sure there's nothing crazy that's happened, and to prep for how many jurors they need to bring in and those sorts of things. So it's just a docket, just a case management hearing. Why they call it that, I don't know. They call them all different things. Do you think the police calls will come in? It depends on for what and when, but they could. I think some of her jail calls are definitely going to come in. So that's going to happen. Let's see. Question, is it possible to populate my Google? Oh, we're working on that. We're working on that in the app. So we are working on it. We are trying to make sure that the app properly sends out notification, but we're working on a calendar in the app that you can subscribe to. It's like literally one of our top things that we want to put into the app. So, alrighty. For those of you that want to catch up on the Adelson case that are newer to the channel and haven't caught up there, I think there's a playlist. If there's not, we'll put one up. But I've done a couple episodes on Donna, and one was kind of a catch-up overview episode. So it's there. All right. And bingo cards for each trial. We're definitely talking about bingo cards for each trial. The next trial I think we're going to get is, let's see. Hannah Gutierrez Reed is going to be the next one. Picking the juries on September 26th. He said the 30th. Why would she use the same lawyer that lost her son's case? I have no idea. I don't know. Kayla asked, how are you feeling? Doing better? Better than I was, but not 100%. So that's where we're at. All right. You guys ready to get to TikTok Psychic? I'm ready to get to TikTok Psychic. Are we plowing through our topics today? Yes. But that's also because I'm going to be streaming tomorrow. Let me see real quick. The court says they're logging off, but there's still a few more minutes of this. So let me make sure nothing else happens, because you never know. So Donna might be thinking that the lawyers are already familiar with the case. So why not?
Thank you, Judge.
All right.
Mr. Friedman?
And these are the next cases, and we're not going to watch the next cases. All right, let's head to Idaho, shall we? And yeah, we've got a lot to talk about in Idaho. So let's try to do a road so far of where we're at. Let me make sure there's nothing new. Hold on, let me pull up the docket. Emily, are you calling an audible? Yes. We're going to log in and make sure nothing else has happened. I pulled these last week to talk about last week. So I want to make sure that there's also nothing new before I run away, which is a perfect time for me to tell you to download the Lawnerd app. I'm not exactly sure what time I'm streaming tomorrow. The app is going to be the best place to know when I am streaming, because I want to hear what happens on that motion in the Hannah Gutierrez Reed case, on the defense's motion to dismiss, alleging that the prosecution disclosed attorney-client privileged information. I want to hear all the arguments on that. I'm fascinated. I was riveted last time. I was so pissed when the court's like, no, you didn't give enough notice. We're putting it over to the next date. I was like, no, this is why I wanted to watch this hearing today. I wanted to see that argument. So I'm really excited to see that argument. All right. For those of you, let me pull up. Emily, don't do a road so far yet. We need to fly. Let's fly. Let's fly to Idaho. Y'all, we started in Idaho. We're circling back around to Idaho. And let's see. There is nothing new in Idaho. So let me give you a brief road so far of the TikTok defamation case. I'm sure you are familiar at this point, but if not, the University of Idaho murders happened. They were much discussed on social media. A psychic on TikTok decided that a professor at the university had hired out the murders due to a relationship that professor was having with one of the victims, inappropriate in that this was a professor at the university and a student at the university. That is an inappropriate relationship between those two parties. It was alleged that that is the cause or the reason why the university professor hired out these murders. And it didn't matter that, Moscow police put out a bulletin saying that they did not believe this professor had anything to do with it. It doesn't matter that Brian Koberger was arrested and is being prosecuted for it. None of that mattered. The defendant in this defamation suit got 2 cease and desist and was like, what I'm not going to do is listen to any of that. I'm going to continue making content on TikTok. Then the lawsuit got filed, because that's what's going to happen after you ignore multiple cease and desist. There's going to be a lawsuit. The defamation lawsuit got filed by the university professor. The TikToker has continued to double and quadruple down on the fact that using their psychic abilities and tarot cards and their intuition and their spiritual research, that they are a spiritual witness to the murders, and everything they said is accurate. And I have no problem at all with anybody. You pick your spirituality. The thing is, what you can't do is use that to harm other people, to defame other people, and to accuse people of murder. So you guys know I love Aphrodite here on YouTube. He does a lot of tarot readings. I love that kind of content, absolutely, for entertainment. I have no problem with it whatsoever. I have an absolute problem using it to defame someone. Absolutely. Using it to accuse someone of murder over and over and over again does not sit well with me. So this is wild, this entire case. And this case would have resolved with I will take the videos down and I'm sorry, it seems to me. But the TikTok psychic was like, no, I said what I said, and is representing themselves in federal court. The status of the proceedings we're at now is that the university professor has asked the court to rule on liability and to add punitive damages. So the professor has said, look, she admitted it. So because she admitted it, there's no actual question of fact. Your Honor, she said all those things. She said she doesn't have any basis of fact for those things. This is defamatory. It's defamation per se. We don't even have to prove anything else. Find liability, and then we'll go to trial on damages. Meaning the trial would be, this person defamed that person. How much money are you giving them? And then you have to try to get blood from a stone, but that's a whole separate conversation. That's what's being asked for. Add punitive damages and grant a motion for summary judgment saying there is no triable issue of fact here. The facts are, she said what she said. I will continue to call them the professor and the TikTok psychic, because I don't think people who want attention should benefit from infamy based on their bad deeds. So I'm waiting to see the judge be like, yeah, you're right. Yeah, you're right. There's no triable issue of fact here. So that was the last 2 motions that we went over. I believe I went over those in January. And now we're going to go through the TikToker's response. Mama One said, didn't get notified on YouTube of you being on. Thankfully, I did on the Lawnerd app. And that's why we have the Lawnerd app. Look, I realize that it is complex to do a whole notification system for an entire platform. That's why we just do our own. We make it awful. Not awful. We make it easy. This is what's awful. Wait, this. The Real Deal said, such a horror story for the poor professor. Yes, it's awful. My brain conflated my response to that and the other question all at the same time. The app is amazing. This story's awful. And it points out how difficult it is to actually protect yourself when people are saying things about you that aren't true. Like, you can sue for defamation. This lawsuit was filed in December of 2022, and we are here in February of 2024, and this thing is still ticking along, and moving pretty quickly. Truly moving pretty quickly, all things considered. Let's see. What she ain't gonna do is cease or desist. That's exactly what's happening. And you can't depose nor cross-examine a spiritual entity that allegedly was the source of the info for the TikToker. Yep. The spiritual guides are not taking the witness stand in this case. So we're going to go to the TikToker's responses to both the motion for summary judgment and the motion for punitive damages. We're going to go to the summary judgment first because, well, I'm real curious as to why the fuck it is 298 pages long. What? Why? What are we doing in 298 pages? Why have I not put this on the screen? What are we doing in 298 pages from this pro se defendant? Defendant's response to plaintiff's amended motion for partial summary judgment. Buckle up, law nerds. Just buckle up. Comes now, defendant in opposition to plaintiff's motion for partial summary judgment. For several reasons, plaintiff's motion must fail. Please enlighten me. Please enlighten me. First, the plaintiff does not meet the criteria for a summary judgment under Rule 56. There is an issue of material fact, and Professor Schofield is not entitled to a judgment as a matter of law. Second, TikToker has not defamed Professor, nor has she admitted to defaming Professor. Well, okay. Third, the burden of proof in a defamation case rests on the plaintiff. I don't know if that's relevant here, though. Schofield does not prove the statement Schoolyard made about her are false. That's that. We're back to the yeah, but prove you didn't though. The entire time, this defendant has been like, you haven't proved that you didn't murder 4 people. That's not how it works though. The plaintiff needs to prove that you have no basis in fact. And you have not proven that truth is your defense. She's like, but she didn't prove she didn't do it. Therefore, as it stands, the statements are legally presumed to be true. Under what standard are the statements presumed to be true? You need objective facts. You need like evidentiary support. For those reasons and more, the amended motion for partial summary judgment must be denied. Background. This is going to be more of the same. The murder of 4 University of Idaho students on November 13th, 2022. 4 students were murdered at a home near the campus in Moscow, Idaho. The tragedy garnered the attention of a worldwide audience on social media and the news media. The attracted audience frantically sought answers as it pertains to who committed the murders and the details of what happened that night. The police received thousands of tips from Good Samaritans trying to solve the crime. Online sleuths and crime networks began their own investigations in an attempt to get answers. Yeah, I don't love that either. There's like a push-pull with all of this because we've seen cases where the online community can be incredibly helpful. When you had other people that were camping in the area where Gabby Petito's body was found, and they had video of the van and were like, hey, this is video timestamped this day. It looks like that van. It's in this location. Incredibly helpful, right? But when you have people throwing in red herrings, not as helpful. So there, again, with this, there is good and bad. The demand for answers went from public. The demand for answers from the public increased as time went by with no arrest. On December 30th, 2022, Brian Koberger was arrested for the murders. I mean, that's a pretty fair summary. TikToker's intuitive tarot readings. TikToker dedicated her life to spiritual development, growth, and mastery since 2016. Okay. She is motivated by purpose, not profit. And she, as she stated in her self-published book, there's a book? Why is there always a fucking book? Why is there a book? Of course there's a book. How did we not know there was a fucking book? Law nerds. How did we not know there was a book? And why is she using the book as evidence? Oh my God. There's always a book. With the books. So she continues to stay mad that the ascribed motive by the plaintiff in this case is that she was making money on TikTok. She is pressed that that is what they are saying. And she is now saying, no. I am motivated by purpose, not profit. And I said so in my self-published book, The Personification of Beauty from 2018, pages 141 and 142. See Exhibit A, page 87 through 88. Did she attach the whole fucking book? Is that why this is 298 pages long? Oh. During her spiritual journey, she developed clairocognizant, also known as clairvoyant abilities. I'm going with clairvoyance because it's easier for me to say. Clairvoyance is this is not quoted. This is just italicized. I don't know if this is a direct quote. Clairvoyance is the ability to perceive matters beyond the range of ordinary perception. Footnote 1, Merriam-Webster Dictionary, clairvoyance. It's not quoted though. Is that a direct quote? Is that a direct definition? What is happening? The Department of Justice published clairvoyance, quote, can offer information for assessment by law enforcement officials, end quote, footnote 2, a link to psychics and police work. No one asked you though. But no one asked you though. No, they didn't come to you and ask for help. You went on TikTok and accused someone of murder. That's very different than working with law enforcement. Those two things aren't the same. Since 2019, TikToker used her clairvoyant abilities to get answers regarding the details of mysterious deaths, high-profile cases, and personal questions as requested. See Exhibit B, excerpt from her unfinished yet self-published book, The Power of I Am, 2019. How, if it's unfinished, how does it have a date of 2019? What is happening? Detailing her development of clairvoyance. Gouliard shared the details of her tarot findings on social media to include TikTok. Lyndon Claircognizant is actually a great drag name. 10 out of 10, no notes. 10 out of 10, no notes. Can the court fine her for all this behavior? The court has been unyieldingly patient, given that she is representing herself. Gouliard routinely received confirming feedback regarding the accuracy of her intuitive readings. Electronically, see docket 57, Exhibit A, electronically stored information, and there's a link to a YouTube video. An intuitive tarot reading that accurately predicted the untimely death of SSG Keenan White. She naturally attracted an audience. Okay. This is in other filings. I feel like it's very invasive to get into this man's taking of his own life and the circumstances surrounding that. But she keeps saying, I predicted that this person would have an untimely death, and they did. And I hate it a lot. But the unfinished yet self-published book from 2019 is killing me. TikToker's involvement with the case of the murder of the 4 students. Yes, how are you involved? 2 weeks after the murders, a concerned TikTok user asked TikToker to conduct a tarot reading to get details regarding the murder of the 4 students. She obliged. Your Honor, it's not defamatory because a lot of people on social on social media were asking me to do it. So it's not defamatory because like they asked. So like it's not my fault. TikToker began the psychic investigation for no other reason than to find answers because she was asked. She's again very upset that they are ascribing a financial motive to this. Her TikTok account was not monetized, nor did she receive payment for the videos posted on TikTok. Gouliard used her clairvoyant abilities to gather all pieces of the puzzle of what happened to the 4 students and why. She became very passionate and touched by their stories, as told by the intuitive tarot readings and their social media footprint. An intuitive tarot reading revealed that Schofield would get away with murder if it wasn't for TikToker. At the time, TikToker did not know how that would happen, but she decided to continue to seek the truth regarding the murder of the 4 students and to advocate on their behalf. Synopsis of the messages received from the tarot readings. The romantic relationship with Kaylee Gonsalves. The tarot readings reveal this. This is not a response with objective evidence. Kat in the chat asked, but is the account monetized now? No, they took away her TikTok account. Tarot readings revealed that Professor Schofield hides that she is romantically interested in women because she is ashamed. However, her desire for victim Gonsalves motivated her to take a risk and to tell her she is interested in her romantically. There's no evidence that these two ever even met. She initially had a mentor-mentee type of relationship with victim Gonsalves. Professor garnered the courage to tell Kaylee about her feelings. Victim was accepting of her and reciprocated the flirting. She then asked victim to experiment with her in a same-sex relationship under the premise that she was gaining the confidence to be her true self. Victim Gonsalves agreed. The relationship was a secret due to the professor being married and a professor. This isn't the response. There was a federal judge reading this first, but the response to the motion for summary judgment needs to be based on evidence, like objective evidence, like grounded in fact. This is just reiterating. I mean, to be fair, she said it. A synopsis of the messages received from the tarot readings. She's just reiterating what she put in the TikToks that got her sued in the first place. Victim Gonsalves, she alleges, grew to love the professor. They spent time together and were romantically involved. As time progressed, victim neared graduation and no longer accepted being in a secret relationship. She did not want to be second place to Schofield's husband. She honored her values and self-worth. Instead, she wanted their relationship to be known. Professor misled victim Gonsalves. She never intended for their relationship to be public. Due to this disagreement, they broke up. Professor told victim Gonsalves that she was feeling neglected by her husband, and that is the real reason she initiated a relationship with Gonsalves. Like, it's not even creative. She then told her that she would not leave her husband because of their family. Victim Gonsalves was heartbroken. She threatened to tell Schofield's husband everything. It was an emotional breakup. But there's literally nothing that supports that. No DMs, no text messages, no nothing. Although victim was heartbroken, she had an amazing opportunity that diverted her attention. This is corroborated by Exhibit C, an article with Kaylee's parents saying Kaylee had a job lined up in Texas and a new car. She looked forward to her new life. However, in the background, Professor was excessively watching her on social media and in person. She was extremely fearful that her secret relationship would be exposed and that she would be embarrassed, lose respect, and possibly lose her job and marriage. The murder plot motives. This just pisses me off. It's just literally reiterating what's in the TikTok videos. This is not bringing anything factually based. After self-torturing herself with, the writing's not good, with the fear and anxiety of being exposed, Professor decided that she would have to have the victim killed to keep her secret safe. She later recognized that victim was surrounded by friends. See Exhibit D, the last photos the victim posted on her Instagram account captioned, "One lucky girl to be surrounded by these people every day." That's the victim's social media account posting that she has friends is not the kind of evidence that you need to support your opposition to a motion for summary judgment. Seriously. She goes on to allege the professor's fear of being exposed, anger and jealousy increased. She decided to include all those around victim in the murder plot as well. All 6 students, including the roommates, DM and BF, who are not named in law enforcement documents. Professor positioned and manipulated Kaylee's ex, Jack DeCore, to commit the crimes. She promised him a better life experience, college life experience, and money in exchange for him to sacrifice his friend or his ex. But where's the money changing hands? Like, okay, so murder for hire plot, right? Donna Adelson, Charlie Adelson. Money exchanges hands. Where's the money exchanging hands? And where's the evidence of the money exchanging hands? Because there's not any, right? They say that Jack DeCore agreed. He helped Professor plan the murders. There's also no evidence that any of these people all know each other. He informed the professor that victim Gonsalves was in town the week of November 11th. Professor insisted that the murders had to occur that weekend. The evening of November 12th, the plan was initiated. The evening of the murders, the Jack DeCore procrastinated. I mean, when's he suing for defamation? Because he's also being defamed. He probably doesn't want to deal with the money that all of this is going to cost because it's so fucking extreme. He played with the dog he shared with victim Gonsalves, ignored Schofield's attempts to contact him. So where are the phone records? Professor panicked. She thought he was deceiving her instead of Gonsalves, or that the task was too big for him. Therefore, she initiated another plan. She contacted Brian Kohberger on an impulse. Isn't this the same TikTok psychic that said Kohberger was the wrong person? Recruited him for the job to kill the victim specifically and sent him to the victim's residence on King Road. Like all in one day? Just called him up and was like, "Yo, can you please go murder people this evening?" And he was like, "Yeah, sure." Like, also, there would be phone activity. Guess whose phone records they have? All of Brian Kohberger's. Because he was never added to this at the beginning. It was, he's the wrong person. He's the wrong person. Now he's, okay. Professor ordered him to check for activity to see if the ex was committing the crimes before doing anything. This is supported by Exhibit E, page 6 of the probable cause affidavit used to arrest Kohberger, which alleges that Kohberger drove by a few times before entering the house. No. When Kohberger arrived at the residence, Jack was already there executing the plan to murder the students. He refused to have Kohberger involved. Sacrificing Kaylee Gonsalves was a big deal to him. He refused to split the money he was promised with Kohberger because if he received anything less from the deal, It would no longer be worth the sacrifice. Most people don't kill for money, though. So for most people, this is not gonna work. Schofield and Jack communicated. Proven how? Proven how? Proven how? They argued due to his lack of communication with her. Proven how? Additionally, she wanted Kohberger to help Jack and for them to split the profit. Proven how? She thought it was more than enough money to go around. Prove it. Jack refused to accept help. Kohberger decided to leave instead. This is supported by DM's witness statement that she saw a masked man walk past her towards the backsliding glass door. No, it doesn't. Sure doesn't. It's also supported by footage of Kohberger's alleged vehicle. Now it's alleged. Of Kohberger's alleged vehicle leaving the King Road neighborhood at 4:20 a.m. See Exhibit E, page 4 and 6 of the probable cause affidavit. The PCA does not support your version of events here. That's not going to fly. The original plan Schofield had with Jack continued. She noted that Kohberger was now a problem that needed to be fixed in the future. Jack increased his communication with Schofield, showing her proof of the crimes being committed. Proven how? The murders. The murders were not done quickly. It was what seemed to be a night filled with chaos and drama. Ma'am? What? This isn't 4 people were murdered in their home after being out all night. This isn't drama. I hate this filing. I'm not often mad at filings. I'm often mad at these filings. There is nothing fact-based here. It is disgusting, truly. This is not what the legal system is for. This is not it at all. This is not it at all. And it's just so fucking appalling. Yeah, chat, yes. Code green. Yes, absolutely. Because the fuck? It's just, oh. I am recovering from being sick. I do not have the words to describe my level of disgust with the fanficking of a quadruple homicide. It's disrespectful to the victims. It's disrespectful to, the professor you're accusing of murder. It's disrespectful to the surviving friends whose names are dragged all through this. And this is not what federal courts are used for. It's like when you're caught in a lie, right? And you're 7. And so it seems like the best idea is to just keep going. Because it's like, it'll work out in the end. It won't. We're getting to the find out of all of this. We're going to keep going through this filing, but this is, it's appalling. She alleges that together they consumed drugs and alcohol that Decor paid for. That would, what there might be with all of that is a paper trail. I don't know. Is weed legal in Idaho? Like, if you're buying drinks, there would be receipts. Exactly. Where are the receipts? Proof, timeline, screenshots. Like, what is happening? Nothing. The students had no idea that he was there to murder them. He supplied them with libations with the expectation to be paid by having sex with one of the victims. After the victim refused to have sex with him, he became angry and belligerent, pretending to be lonely, cheated on, deceived, and used for his drugs, but it was all a ploy. If there were drugs in the house, they would have probably been recovered during all the searches of the home. Also, I think there was a lot of digital evidence that the victims were all out earlier in the night. They were like out doing other stuff. They weren't at home drinking. They all came home late. After this went on for a while, a couple of the girls began to have sex with him to calm him down and pay the debt. What? This is a disgusting fanfic. It's so fucking weird. Ethan was uncomfortable with the situation. I don't think any of this is true, and I'm uncomfortable with the situation. There was a physical altercation. Ethan got the best of Jack. The situation calmed for a while. Ethan wasn't buying it. The story did not make sense. Sometime later, the Koberger incident happened. What Koberger incident? Ethan confronted Jack again to protect the girls. He was attacked instead. Look, none of this makes any sense with the way that these murders happen. None of this makes sense with the crime scene. All of this is absolutely preposterous. They say Ethan was the first to be stabbed. Xana stayed with Ethan, attempting to help him. She feared she was being watched. She hoped to be... No. She thought the surviving roommates were going to get help. This is supported by the probable cause affidavit. No, it's not. She alleges that the surviving roommates hid to protect themselves, that Xana didn't want to call the police unless she had no other choice, that she decided to face her fears to help herself and the other victims. And then it alleges what they did that night when they were all killed. I don't believe any of it. This is all disgusting. I'm not... no. Procedural history, good. Let's get to the procedural history instead of her fanfictionizing what happened and trying to use the probable cause affidavit to back up her fiction. It's just too fucking much. Procedural history and harassment. To discredit TikToker, her reputation, character, account of events, and legitimacy. Your account of events is not grounded in facts, though. So, to discredit the TikToker's reputation, character, account of events, and legitimacy, on December 21st, 2022, Schofield fraudulently filed a 2-count defamation complaint against TikToker. The complaint was completely fabricated and filled with the intent to harass and take revenge against TikToker for exposing the affair with victim Gonsalves and her role in the murder of the 4 students. No. That's not what happened, though. That's not what happened, though. And this is why fighting with pro ses, with this pro se, isn't going to go anywhere. Because all of the filings have been logical. And her takeaway is that she is being harassed and that they're out to get revenge on her. No. They asked you to stop saying things that you can't prove are true. And you said no. And now we're here. In nearly all their dockets within the complaint, Schofield and her attorneys make false statements of fact about Gouliard's character, mocked and degraded Gouliard's spiritual practice, and misled the court regarding the nature of the complaint. The complaint's the complaint. On the 4 corners of it, it is what it is. They didn't mislead the court regarding anything. Why am I just arguing this? Because I can't not. This is maybe the worst filing we've seen from this pro se so far. It's the most offensive, that's for sure. Within a week of filing the complaint, the professor and her attorney started a smear campaign against TikToker using the news media to embarrass the TikToker. Well, if you feel embarrassed, that's on you. To spread lies about her and to annihilate her character. They told the news media that TikToker intentionally fabricated lies about the professor's involvement in the murder of the 4 students for self-promotion and to profit from the tragedy. That was a lie. It is. Where's the lie? Is it the profit part? Because I feel like she's getting hung up on it's the profit part. The truth is, oh, you're going to tell me where the lie is. Emily, keep reading. The truth is that the TikToker used her keen clairvoyant abilities to get truthful answers on what caused the murder of the 4 students. She posted TikTok videos to promulgate the truth and to seek justice. She's seeking justice, you guys. Okay. Her TikTok account was not monetized. She did not profit from the videos about the 4 students or any other video on her TikTok account. But did you like book additional readings and stuff? Like there's other ways to monetize that. I have questions. They told the news media that TikTok re-victimized the families of the victims. That was a lie. Ask the victims how they feel. Ask the victims' families how they feel. The truth is she was attempting to get justice for the victims. I don't think they see it that way. Toya said Delulu is not the Solulu. I love that creator. I love that creator. Yep. Professor and their attorneys' egregious false statements of fact about TikToker were massively published. They embiggened. Massively published in multinational news media outlets and multinational social media channels to multi-millions of viewers. Multi. The lies were accepted as true and caused TikToker to be harassed on social media, her website, on book reviews, telephonically, and by email. TikToker's spiritual practice and personal reputation was ruined. Well, I mean, you're in control of your own spiritual practice. I don't know if they did anything other than bring light to what you were saying, though. Her TikTok page was continuously targeted by fake social media accounts and professor supporters. Her TikTok page was ultimately banned from TikTok due to professor and her attorney's false allegations against her and due to the near continuous false reporting of community guideline violations on her post. Is accusing someone of murder without any evidence a community guideline violation? It feels like maybe yes. Knowing the complaint and their subsequent dockets, do they mean subsequent filings? I guess so. Their subsequent filings were completely fabricated and that the professor did not suffer any damages from the tarot reading. Professor and her attorneys abused the judicial system by seeking multi-million-dollar judgments against Schoolyard. Okay, first, defamation per se. Second, reputational damage is part of the damage. They continue to use the judicial system to harass TikToker. The TikToker is being harassed. Y'all, if anybody does a study on gaslighting, this document is fascinating. Fascinating. So the professor is harassing the TikToker consistently. Outside of court, professor and her supporters continuously harassed TikToker on social media through the creation of newly created fake TikTok and YouTube accounts used to threaten her life, make false statements about her mental health, and threaten a quote-unquote hate crime against her. First of all, in the years I worked in the criminal justice system, I did not see people threatening hate crimes. I've never once seen somebody saying, I'm going to hate crime someone. Like that's just simply not how that works. Also, I don't think making death threats against someone on social media, no matter how abhorrent that person's behavior is okay. Don't make death threats. Don't engage. If there's community guideline violations, I mean, there's community guideline violations. That is what it is. But making threats against her, I don't think is okay. I also don't think there's any evidence that the professor is the one doing that. The professor sent cease and desist and said, "Excuse me, ma'am, if you do not stop, we will sue you." And then she did not stop. And then they sued her. That's not harassment. That's process. Also, this pro se defendant represents themselves and puts their address and phone number on all of their filings. Like, if you're going to represent yourself pro se, you've got to get another address that you can use in court filings. Those are public. Don't do that. Okay. Outside of court, she says the professor, I don't think there's any evidence of that, and her supporters continuously harassed TikToker on social media. Professor supporters routinely called Gouliard's personal cell phone number several times, referring to Schofield as an innocent professor, asking Gouliard who is the killer, even calling on Christmas Day. The calls increase when Gouliard faces litigation deadlines. Don't do that. Just don't do that. Don't do that. People shouldn't be calling and harassing her. Like, that's also not okay. Like, when do we get back to the you can have your opinion about this TikToker and what they're doing, but you don't need to call them on their phone and scream at them. Asking Gouliard who is the killer. Oh, I said that. In fact, as Gouliard wrote this response, she received several harassing phone calls to her personal cell phone number from a Schofield supporter with a made-up phone number asking, "Are you the killer?" And she put those on YouTube and attached those videos as exhibits. Okay. Multiple things can be true at once. This TikToker's behavior is disgusting. People should not be calling and threatening her life. Like, nobody needs to be involved in it. If you want to read the court filings, read the court filings. People don't need to get involved. If you want to support the professor has a GoFundMe. Go support the professor. I'm sure she can use the money to pay for her legal fees. Two things can be true at once. You can hate something. It doesn't mean you need to call the person and threaten their life. Don't do that. That's not okay. However, none of the magic carpet ride that we just went on, none of that fantastical journey in any way opposes the motion for summary judgment. We're in a motion for summary judgment. None of this opposes the motion for summary judgment. Her getting threats has nothing the fuck to do with the motion for summary judgment. Like at all. Like at all. Like, we're 9 pages in, and I'm yet to find an opposition to the motion for summary judgment. I have not found it. I don't know where it is. Shiraz says, "Judge, can you just issue a decision here already? I need it to happen." Amy Field said, "Can she get jail time?" No. She hasn't done anything to warrant jail time. This is a civil defamation lawsuit. Money is the response. But she hasn't, like, ignored court orders. I mean, there's nothing she's done on this record that would warrant that. This is my least favorite filing to date. Legal standards and argument. Oh, good. Because what we don't have yet is facts. We haven't gotten any facts yet. Notwithstanding the fact, just saying the word doesn't count. Notwithstanding the fact that plaintiff's entire complaint is completely fabricated and fraudulently filed. Notwithstanding that. It does not meet the criteria for a summary judgment favorable to plaintiff under Rule 56. Please tell me more about Rule 56, ma'am. There are several genuine issues of material fact, and they are what? I have not yet seen an issue of material fact yet, and you have not pointed it out to me. You've bitched for 9 pages about the fact that people have been mean to you on the internet. and that your version of events that is not supported by evidence anywhere is the truth. This is a defamation lawsuit. It's not like a my truth situation. There has to be objective facts. Okay. Additionally, the plaintiff is not entitled to judgment as a matter of law because she does not have a valid defamation claim. Tell me about that. Pursuant to Rule 56 of the Federal Rules of Civil Procedure, in order to succeed in a motion for summary judgment, the movement must show, 1, there is no genuine dispute as to any material fact. Agreed. Accurate. Yep. TikToker has consistently persisted. Hold on. My A-word device is going crazy. Cancel. TikToker has consistently persisted that the statements she made regarding the professor's role in the murder are substantially true. Well, yes. That's the whole problem. This is the problem. That she has persisted that the statements she made are substantially true when there's no evidence that they are. She has said these things are true and there's no facts to back them up. That's why we're here though. Okay. In this civil defamation case, professor has the burden of proving she did not have an affair with the victim and she did not murder the 4 students. Ma'am? No. And then she's citing case law. Quote, allowance of the defense of truth with the burden of proving it on the defendant does not mean that only false speech will be deterred. The First Amendment requires that we protect some falsehood in order to protect speech that matters. Therefore, the legal assumption as required by the First Amendment is that Gouliard's ideas are not false unless otherwise proven. That's not what that stands for. No, that's not what that means. God, am I going to have to start key citing cases? Is this still good law? We need to shepherdize things. Okay, no, Emily, you're not a legal research assistant. We're reading the arguments on the paper. We begin with common ground. And I think she means to put this in quotations, even though it's just italicized. I think she's directly quoting the case, but I'm not quite sure. We begin with common ground. Under the First Amendment, there is no such thing as a false idea. But this is a defamation case. However pecunious an opinion may seem, we depend for its correction not on the conscience of judges and juries, but on the competition of other ideas. But this is what? The falsity of Gouliard's statements have not been proven. Therefore, the default position is that the ideas about Schofield, she's calling them ideas now. Ideas, her just thoughts. Her ideas about the affair and the role in the murder are presumed true. No. Can you imagine trying to fight this in court? Like we're in the land of clueless again with how can I do my assignment if she refuses to do hers? The plaintiff is trying to litigate and the defendant is like, I know you are, but what am I? That's this entire case. Nuh-uh. It's true. But nuh-uh, Your Honor, they have to prove that it's false. No. You have to prove that there is some basis. Like, truth is a defense. Truth being a defense doesn't mean it defaults to being presumed as true. But this is bananas. Tori said my husband, a lawyer, said no at the same time Emily did. But it's these things are so frustrating for lawyers because the response, you can't write the response to the court that just goes, Your Honor, no CEG law. Like, you actually have to try to break down the I know you are, but what am I defense and actually argue against it when all this is circular arguing, citing cases that don't even necessarily seem to be relevant. Pursuant to Rule 56C1B, a party asserting that a fact is genuinely disputed must support the assertion by showing that the materials cited do not establish the absence of a genuine dispute or that an adverse party cannot produce admissible evidence to support a fact. They've done that. You now have to undo that. They did that in their motion. Schofield's argument for summary judgment is frivolously supported by TikToker's admissions, the TikTok videos that TikToker published, and a false declaration from the professor. So you accused her of lying. First, TikToker's admissions established that she used her clairvoyant abilities to get information regarding the murder of the 4 students and the professor's role in the murders. Those admissions do not support the burden to prove that the ideas are false. You have misunderstood all of this willfully. This is a willful misunderstanding of what you're required to show. And the circular reasoning here is infuriating. It's not... The TikToker admitted, I said that. There's no issue of fact. There's no disputed issue here. You said it. And you said you have nothing to base it on other than your own ideas. But help me see the issue for a jury to decide. The professor said, she said this about me. It's defamation per se. And then the TikToker said, yeah, I said that about you. And instead of saying it's based off of anything, she said it's based off of my ideas. There's no issue of fact there. Second, TikTok videos established that she promulgated her ideas regarding the affair and the role in the murders. Yeah. Yes. She then goes on to say, the TikTok videos do not support the burden to prove that the ideas are false. But it proves that you said it, though. Lastly, Professor's declaration establishes that she denies having an affair with Gonsalves and denies she was involved in the murder. Schofield's declaration do not support the plaintiff's burden to prove that Gouliard's ideas are false by preponderance of the evidence or with convincing clarity. Ma'am, it's what? No. And then she cites something, I think, because she's putting it in it's italicized instead of in quotes, but it says, in a civil case, the plaintiff must convince the jury by a preponderance of the evidence, i.e. that it's more likely than not that the defendant is responsible for the harm the plaintiff has suffered, footnote 3, to a general article about federal cases. Schofield's word does not amount to a preponderance of the evidence. No, that's not how it works. Nope. I need the judge to rule on this because I need it to I need it to stop. Like I need this to be done. Steven said, it's giving law masterclass by Temu. Yep. Okay. It's illogical to expect someone who is willing to kill to keep her secret safe to in turn admit to quadruple murder and an affair with a female student. But Your Honor, like that doesn't make sense, Your Honor. Your Honor, her argument is literally, yeah, but she's a murderer. Like, who can believe what she says anyway? What? Just picture a federal judge, kind of at the kind of top of their career, becoming a member of the federal bench is not easy. It is reserved for the nerdiest of the nerd lawyers. It is very scholarly and stoic and a very prestigious position. And they're sitting there reading this. Do you think that federal judge goes home and is just like, so today someone submitted fanfic as an argument, and I don't really know what to do with that? Or do you think they're just sitting there going, and this is why the court systems are clogged? Because I don't know what the professor is supposed to do. Like, and I don't have any confidence at all that even when this TikToker loses, I don't have any confidence that they're going to stop. And I don't think there's much that can be done. So, it is illogical, says the TikToker, to expect someone who is willing to kill to keep her secrets safe to in turn admit to quadruple murder and an affair with a female student. Additionally, during the entire litigation and in every docket, I think she means filing, Professor and her attorneys have continuously misled the court and the public by spreading the false narrative that TikToker intentionally lied to gain a profit from the tragedy. She is very pressed about that. Okay, but why else did you do it then? They also fabricated nearly $2 million in damages despite Schofield having no actual damages. That's an argument for a different day, ma'am. That might be an argument for the jury once you're found liable. They made those false statements under oath with the intent to mislead the court and the public. The court's already told her to stop barking up this tree, but that's not happening. TikToker is the only party that has consistently upheld her ideas and integrity the entire litigation. She typed that. Therefore, Schofield's word does nothing to prove anything except that she's willing to lie and perjure the court to get her way. She is accusing the professor of perjury. Truth is a valid defense for defamation and is still being disputed. Ergo, Schofield fails to meet the criteria for summary judgment. Thus, the plaintiff's motion for summary judgment must fail. No. No. Schofield is not entitled to a judgment as a matter of law and fails to meet the criteria under Rule 50A and 56A. Plaintiff erroneously claimed that Gouliard, quote, has admitted to defamation as a matter of law. Pursuant to 56A of the Federal Rules of Civil Procedure, in order to succeed, you're just repeating yourself. In a motion for summary judgment, the movement must show, too, that the movement is entitled to judgment as a matter of law. Rule 50A1B requires that the court may grant a motion for, well, it doesn't require, it allows, may grant a motion for judgment as a matter of law against a party on a claim or defense that under the controlling law can be maintained or defeated only with favorable finding on the issue. For a defamation claim to be valid, to include defamation per se, the statements must be false. Yes, the statements must be false. The elements of a defamation claim applicable here are as follows. We don't need to repeat this. The plaintiff must prove that the defendant communicated information about her to others. Proven. 2, the information was defamatory. Proven. 3, she was damaged because of the communication. Doesn't need to be proven because it's defamation per se. Because we're in defamation per se. We're in defamation per se. Wolf Chiara said, didn't she countersue at the beginning? Yes, and those all got yeeted. I should actually, here, I'm just going to make me a little bit bigger. Because Lord save us all. All right. It might cover up a little bit of this, but we'll make it work as we're scrolling through. Nope, that's too annoying. And that's too small. All right. We're going to let's see. Emily, why are we all of a sudden playing with our layout? Well, because some days there's only so much you can do. And today is one of those days. It's just, what in the world is happening in this filing? Maybe like that. We're going to see how that goes. I'll stick to the upper third. TikToker adamantly states, okay, how adamantly you state something is not the test here. TikToker adamantly states that the statements she made about plaintiff are substantially true. Professor has the burden of proof and has not submitted convincing evidence that the statements TikToker made are false. No. Gouliard's ideas are presumably and legally true. No. Truth is an absolute defense against defamation. Okay, but for it to be a defense, you have to prove it, though. The ball is in your court. Thank you for quoting New York Times versus Sullivan. True ideas and statements cannot be defamatory. Okay. Just because you think it's an idea doesn't mean it's true, though. Just because you think it doesn't mean it's the reality of the situation here. The plaintiff's complaint does not meet the elements of a defamation claim. This is not a 12b6 motion. This is not a motion to dismiss for failure to state a claim. That fucking ship has sailed. We're in a motion for summary judgment. This is an evidence argument, and you've put forth no evidence. It goes on to say that plaintiff's complaint does not meet the elements of a defamation claim. Therefore, Schofield's not entitled to a judgment as a matter of law. No. The plaintiff has the burden to prove the ideas are false. I think the plaintiff has done that. Plaintiff erroneously places the burden of proof on Gouliard in her motion for summary judgment. No. What she said is you admitted it, and now you have to oppose it. The plaintiff bears the burden of persuasion at trial and bears the initial burden of production and summary judgment. The plaintiff in a civil lawsuit has the burden of proof of preponderance of the evidence. The burden of proof for a defamation case also rests on the plaintiff. Okay, we're not going through these statements of the law. They are not. No. Schofield does not produce clear and convincing evidence. That's a different standard. We're not talking about clear and convincing. We were talking about, okay. This is just such a fucking word salad. Schofield does not produce clear and convincing evidence that Gouliard's ideas are false. They're now ideas. Her ideas. Her allegations. Her defamatory statements. Instead, her evidence supports that Gouliard's allegations about, now they're allegations. Gouliard's allegations about Schofield were not investigated by Moscow police. Therefore, because TikToker promulgated ideas about the professor's role in the murder of the 4 students and the affair had not been investigated, there is no evidence to prove their falsity. No. The police said the professor is not connected to the murders. I don't know what more you want, ma'am. In other words, thank you for restating this for us. In other words, it is legally true that Schofield hired an unexperienced hitman to commit the murders of 4 University of Idaho students. And it is legally true that Schofield had an affair with Kaylee Gonzalez. No. No. False. Gouliard's ideas are not false statements of fact. The term, quote unquote, misrepresentation of fact is defined as, but defined by who? Is this in quotes? Is this a direct quote? Is defined as, quote, a false statement of substantive fact or conduct that leads to a belief of a substantive fact material to proper understanding of the matter in hand, made with intent to deceive or mislead. See 41 USC 71019. A false or fictitious statement or representation is an assertion that is untrue when made or used and that is known by the person making it to be untrue. And what does that have to do with anything? Let's see if she ties it together. TikTokers' statements were made in the best interest of public safety and with the intent to help solve a horrific crime. By saying them on TikTok? Is this real? Leanne Taylor, I feel like I'm being punked. Her statements were made in the best interest of public safety and with the intent to help solve a horrific crime. Then make them to the tip line, not to TikTok, though. 4 students were brutally murdered. She believes that her ideas can help solve crimes and get the right people arrested. I, I can't. There's. I don't know even how to respond to the wrong things anymore. Best interest is not the standard here. This is an opposition to a motion for summary judgment. We need the opposing evidence showing that there are issues of material fact, and the circular argument of like the snake eating its tail is just but I believe that it's true, but I believe that it's true, but I believe that it's true. That doesn't make it true. There's not enough lipstick in the world today. Gouliard's tarot readings have a track record of being accurate. Irrelevant here. All of that is irrelevant here. Therefore, the promulgation of her ideas is not reckless, careless, nor an intentional lie. She's trying to argue that she believes it's true. And that because she believes it's true, therefore it's true. And that she has a reason to believe it's true because of another case, which is irrelevant. The potential benefit and value derived from her ideas, the arrest of quadruple murderers, far outweighs potential damages. That's not a balancing test. That's not the balancing test. That's not it. Especially considering Schofield did not suffer any damages. You say she didn't. She says she did. That's an issue. That's a material issue. That's a material issue to be decided. See, the argument about damages is actually a material issue to be decided by a jury. That's what that looks like. You say she has no damages. She says she does have damages. That's an issue. And the jury can decide. Gouliard's ideas do not meet the intent of a false statement of fact and are deserving of exploration, exposition, and protection. No. No. Okay. The use of clairvoyance in law enforcement is not implausible. This also doesn't go in any direction towards helping argue. We're still arguing an opposition for a motion for summary judgment. This is not that. You're not helping law enforcement. Law enforcement didn't ask you for shit. In previous filings, the court erred in deeming clairvoyance and derived ideas as arguably so outrageous as to be clearly baseless and thus implausible. The court did say that. However, the CIA recognizes that, quote, psychics have been helpful in providing law enforcement with unknown information which was helpful to their case. That's also a word salad. Recognizing that the investigator might develop a theory about a case and ignore important clues that could be highlighted by a psychic in cases with a large number of suspects, the psychic could help the investigator concentrate on more likely suspects early in the investigation. Footnote 4, CIA.gov reading room, something on psychics. I don't trust the link. We're not doing it. See Exhibit G. Oh, good. Wait, why? Oh, now there's apostrophes. Gouliard's clairvoyant abilities and spiritual connection is authentic and elite. Ma'am, the CIA didn't ask you for help. Law enforcement didn't ask you for help. When you're working with law enforcement, you're just saying things to law enforcement. This is not This is not that. It is unlawful to deem the information she provided as false. It is? That's news to me. It is unlawful to deem the information she provided as false simply because she was not physically present. Did y'all know that? Did y'all know that? That's not true. See how you can just say things recklessly? That's not true at all. You see, lawyering is harder when you have to base it on like facts and case law. When you can just like say whatever, I realize it seems easy, but it's actually not though. It's not unlawful to deem information false because she was not present. Yes. Alexandria in the chat said it's not lawful law. That's where we're at now. We have reached full Brooks. Full Brooks. It's not lawful law. It's not lawful law. War Eagle Pharma D said, is this TikToker representing herself still? Oh, yes. Oh, yes. That is that. Yes. That's what's happening here. As stated by the CIA, last I checked, the CIA weren't binding authority on any courts, but okay. If anyone, lawyers in the chat, if you want to let me know what binding authority the CIA is, that would be great. As stated by the CIA, it's not required for clairvoyants to be physically present to gather and provide information, yet the information can be helpful to law enforcement. You weren't providing help to law enforcement, though. Conclusion: for the reasons stated herein, Gouliard's intuitive ideas that the professor hired men to murder and ensure the murder of the 4 University of Idaho students is presumed to be legally true. No. Gouliard's intuitive idea, these are now ideas. These are not statements anymore. These are now just ideas. She's like, look, Your Honor, it's a thought. Like, it's just a thought in my head. No. Gouliard's intuitive idea that the professor had an affair with one of the victims is presumed to be legally true. No. The plaintiff has not yet proven the statements to be false. No. You just keep making conclusory allegations. That's not an argument. That's just saying a bunch of conclusions and hoping that the court goes, you're right. No. Unless the plaintiff agrees that the statements Gouliard made are true, the truth or falsity of the statements are still in dispute. Therefore, the plaintiff does not meet the criteria for a summary judgment as required by Rule 56. I mean, she did bring it back around. Additionally, the plaintiff has failed to claim a valid defamation claim because the truth cannot be defamatory. The plaintiff's motion for summary judgment must be denied. And she put in a prayer for relief. I didn't know you got to do that in opposition. That's unique. Deny the plaintiff's motion for summary judgment. I mean, that's your conclusion. Award the defendant all court-related fees and sanctions. She's asking for sanctions for $1 million. Sure. File the motion for sanctions then. Sanctions. Oh, there's a footnote. Footnote 5. Sanctions totaling nearly $1 million were upheld by the Supreme Court for the petitioner's 1, attempt to manipulate the court of jurisdiction by acts of fraud, 2, filing false and frivolous pleadings, and 3, attempting by other tactics of delay, oppression, harassment, and massive expense to reduce the respondent to exhausted compliance. That's not what's happening here. Exhibit A, book, The Personification of Beauty, see pages 87 through 88. I'm gonna wait. Damn it! I move here. Let me just do this. I'm sorry to all the co-authors. I'm sure you are lovely. For permission requests, speaking inquiries, and bulk order purchase options, email Ashley at liveinfantasyland.com. That's not real. Published by Live in Fantasyland, LLC. Fucking flawless. fucking flawless. No notes. No notes. No notes. No notes. Look. Do you think the plaintiff's attorneys were like, well, I think we need all of the background on liveinfantasyland.com. Also, I need to know if Disney has Fantasyland trademarked. I have so many questions. So Ashley at liveinfantasyland.com is where you can do that. No part of this book may be reproduced. Well, here it is in a court filing, I think. So, dedication to women of purpose. May we know them, be them, and see them. I feel like, whose quote is this? I don't know. Chat will probably know. Who is, may we know them, be them, and see them? Who is this ripped from? Okay. Acknowledgement introduction, chapter 1, dream like Cardi, mindful like Michelle, slay like Rihanna, take a stand like Solange, excellent like Beyonce, a spirit like Maya, command like Taraji, heart like Harriet, the makings of me like Monica, escape like Candy, win like Serena, and then about the 3 authors. Is this the whole book? Is this the whole book? Is this the whole book? Wait, there's notes and acknowledgments from 2 of the authors, but not from this author, which is interesting. So I don't see an acknowledgement from this defendant. The personification of beauty, Oprah Winfrey. Does Oprah know? Oprah would like to, I'm going to guess that Oprah would like to be excluded. It is the insatiable dedication to uncovering the absolute truth that keeps us from turning a blind eye to corruption and injustice. This is about a speech Oprah gave. This is a book. Okay. And then they quote the Bible. Whose story? Let's see. The chapters of the book are named after women who have mastered the craft of their foundations and live by the keys in their everyday lives. They are the personification of the key foundational principles of beauty. Ashley, it is only fair we start off with an overview of our stories, the stories that built our strength and contributed to the women we are today. My story is one of resiliency, robustness, and determination. However, it started with a massive amount of rejection and constant fear. Rejection so powerful that it was used as fuel for selfish ambition, only cured by the principles taught in this book, making my pursuit of excellence purpose-filled instead of vain. In the chapters I wrote, you will notice that I use the pronoun she in reference to God. It is a widely known fact that God is not human. Therefore, God is not a male. However, many translations of the Bible use masculine labels to refer to God in an effort to adhere to cultural normities that the male sex is superior to the female sex and to make God relatable. As a result, I am required to explain why I use the pronoun she in reference to God instead of he. God is just as feminine as masculine. I mean, okay. I use the pronoun she. My co-authors use the pronoun he. Neither are wrong. Now let's move along. Okay. This looks like an entire book. We're going to have to, y'all. It's the whole book attached. The entire book is attached. We're going to have to get to the end of the book and see what else is attached, because the entire fucking book is attached. Not the pages that were referenced. The The entire book. The entire book. Page 88 and 89. I think so. She submitted the whole book. Yes. Oh my God. Are we still on the book? Yeah, I'm moving. I'm trying to move along. I'm baffled. I I I don't know, y'all. I don't. The whole thing didn't need to be submitted. For one. All right. We just I would like to get on to the next exhibit, but the entire book is attached as an exhibit. Are we almost done? That's about the author. That's about the author. Defendant is a Chicago native, an entrepreneur of a digital publishing company, live in Fantasyland, and the author of numerous books. There are numerous books. She says she is also a combat veteran of the United States Army, a member of Alpha Kappa Alpha. Sorry to all the alphas in the chat. And mother of child, a purpose-driven millennial. She is widely known for her passion in encouraging people to pursue excellence and to become the person that God has called them to be. Okay. Exhibit B. Oh, thank God. Does the judge have to read the whole book? Mama 1 asked in the chat. No. I need to do something else today. Me just rearranging is the fact that all of this is bananas today. Here, we'll just do this. No. The judge does not have to read the whole book. She cited like 2 pages. And yeah. No. The Power of I Am is the not finished self-published book. Edition 1 is an excerpt, chapters 3 and 7 from The Power of I Am. It teaches the heart of wisdom. So this is a publication of Live in Fantasyland, LLC. All rights reserved. This is from 2019. I don't know if this is, I don't know. We're going to try to get past this and see what else is attached here. These are excerpts from the yet unfinished book. I don't know how any of this is relevant. She says that because she said it in the book, that she's not profit driven, that it's true. She didn't submit an affidavit. So, she just submitted the book instead. That's not going to fly. It's not, evidence. She's like, but because I wrote it, Your Honor, it must be true. Even though what the plaintiff wrote is not true. So this is and then printouts of an article. Parents of murdered Idaho student say she was preparing to move to Texas before slayings. She had a job with an IT firm in Austin and recently moved out of the house where she was killed. That's tragic and sad, but it's not relevant here. I mean, she was graduating in December. Okay. Exhibit D taken from Instagram, and then there's pictures taken from the victim's Instagram saying, look, see, Your Honor, she's surrounded by friends. It says so on Instagram. Exhibit E is the probable cause affidavit. I went through the entire PCA in other content. There's nothing in the PCA that she is making it mean things that it does not mean. These are links to a YouTube video with phone calls of her harassment, which shouldn't be happening, but does nothing to oppose the motion for summary judgment. Exhibit G, the use of psychics in law enforcement. When was this fucking typed? 1952? What in the typewriter is happening? Use of psychics in law enforcement. Approved for release 2000. My bad. It's from the year 2000. 1950, 2000. Like, you guys, this is not. This is not This is not the situation here, though. During the past year, numerous articles have appeared in national and local newspapers and magazines describing the use of psychics in police investigations. Even though they are being consulted by federal, state, and local law enforcement, psychics are not commonly used in investigations. The media articles and lack of exposure by most investigators to psychics leads to two interesting questions. Have psychics successfully aided investigators in cases? What should an investigator expect if they choose to involve a psychic in a case? Okay. This is an exploration of whether or not law enforcement can consider the use of a psychic in a case. Okay. But that's not what happened here. Conclusion. Based on this survey, it would appear that a talented psychic can assist you by helping to locate a geographical area of a missing person, narrow the number of leads to be concentrated on, highlight information that has been overlooked, or provide information previously unknown to the investigator. When the defense asks you to turn over evidence of like how you narrow down the suspects, that would be an interesting conversation. This is linked to another YouTube video, and that is the end. Oh God. There's another motion. There's another motion. Jen said, do cases like this hurt the justice system? Curious. I don't think they do. This civil litigation, different from criminal litigation, is the only avenue to vet and to deal with things like this. What was the professor's choice? File the lawsuit or don't file the lawsuit. If she doesn't file the lawsuit, this is not going to stop. And even filing the lawsuit, she can't make it stop. At least it puts the difficulty of what the professor is going through into the spotlight, and hopefully illuminates the fact that people can do tremendous harm by saying shit about you on the internet. And then the method to unwind that is difficult. I feel awful for this professor. I truly do. But I think the defendant is continuing to like dig her own hole, and like cover herself up in it while she's in it, because the next motion is against the leave to amend for punitive damages. And that's what we're going to take a look at next. So let's take a look at the motion regarding punitive damages. And a lot of what the TikToker has said proves what the plaintiffs are arguing, that she said what she said, and she doesn't give a fuck. And she's going to continue not giving a fuck. So let's continue on. Punitive damages comes now defendant in opposition to the motion for leave to amend the complaint to add punitive damages. Idaho Code, she says, requires that a claimant prove by clear and convincing evidence oppression, fraudulent, malicious, or outrageous conduct by the party against whom a claim for punitive damages is asserted. Plaintiff has not proven the defendant to be wrong. We're still there. Nor has plaintiff proven by clear and convincing evidence that that TikToker behaved maliciously, fraudulently, outrageously, or oppressively. Chat. I don't know if we're at fraud, but I think the legal definition of malice is probably here. I also think the legal definition of outrageous, like all of Britney's entire song of outrageous, is here. So she says the court must deny Schofield's motion for leave to amend. Background: the murder, the intuitive tarot readings. Oh, good. This is a complete restatement of the other motion. Fantastic. We're skipping that. Involvement with the case. Skip. Synopsis of the message received from the tarot readings. Skip. The murder plot and motives. This is all copy and pasted from the other. I don't know how this helps. This is a direct copy and paste from the other motion. Legal standard. The plaintiff's complaint does not meet the standard for punitive damages. That's not what they're saying. They're asking for leave to amend so that they can add it. Plaintiff's entire complaint is completely fabricated and fraudulently filed. Good. It does not meet the criteria for punitive damages. The defendant admits to communicating on social media that the professor ordered the murder of the 4 University of students to prevent from being exposed for having an affair. Right. However, plaintiff did so in a noble attempt to help law enforcement solve the crime and for justice. Can we go back to defendant admits to communicating on social media that the professor ordered the murder of 4 University of Idaho students to prevent from being exposed for having an affair? Can we go back to that? The noble attempt is irrelevant here. This is exemplified by Exhibit A, Gouliard's tip she sent to the FBI tip line. Maybe you should have just left it at the tip line and not put it on TikTok. Murder is a public safety issue. Oh, we've got a public policy argument, y'all. That cardinal is, there is a juvenile cardinal outside on the bird feeder that has just been teasing the cats, and it is hilarious. She wanted to solve the crime, as so did other members of the public who sent thousands of tips to law enforcement and reported their findings on social media, news media, and television. Additionally, Your Honor, excuse me, Your Honor.
Your Honor, like, all the other girlies were also calling the FBI tip line and, like, putting it on social media that they called the tip line. So, like, everybody was doing it. So I don't understand why, like, it's a problem. Like, I was trying to help. And, like, I told all of TikTok that this professor committed the murder because, like, justice.
Additionally, back to document. Additionally, TikToker believes that the statements she made regarding the murders and the affair are substantially true. What parts do you believe are not true then? If you only believe it to be substantially true, what parts do you think are now false? Because I have questions. Malice requires that the statement was made with knowledge of its falsity or with reckless disregard as to whether it was true or false. The plaintiff has failed to prove clear and convincing evidence that Gouliard's conduct was malicious, outrageous, or ill-intended. Your Honor, it was noble. The motion to amend to add punitive damages must fail. Plaintiff's complaint is fabricated, promulgates a false narrative, and is misleading to the court. The plaintiff intentionally misled the court and the public with the false narrative that Gouliard intentionally made up false stories and published false statements about the professor to TikTok to use the tragedy as an opportunity for pecuniary gain. Excuse me. The plaintiff and her attorneys chose to lie to the court about the intent and character because they intend to abuse the judicial system to embarrass TikToker, humiliate her, destroy her spiritual practice and character, and prevent professor from being investigated for murder. TikToker has proven that her character and behavior is not so outrageous. Did I miss something? Where did that happen? She did not lie. She did not make up stories about the tragedy for pecuniary gain. So clout then? She did not post false statements about the professor, knowing they were false. Instead, she used her highly developed and highly studied clairvoyance to help solve a quadruple murder. She was motivated by purpose, not profit. Oh, and she cites the book again. The plaintiff's dishonesty with the court and the public does not warrant an opportunity to amend the complaint for punitive damages. The plaintiff does not have and will not get clear and convincing evidence that Gouliard acted with malice, ill intent, fraud, or oppression because just like her false narrative, the evidence does not exist. On the contrary, TikToker has evidence that she has not acted with malice, ill intent, fraud, or oppression. What's that evidence? Because I said so? Your Honor, because I said so? Okay. Amending the complaint is not in the best interest of justice. First, defendant TikToker does not consent She did not consent to you accusing her of murder. That's not the game we're playing here. First, defendant does not consent to plaintiff amending her complaint to add punitive damages. Second, adding punitive damages to a frivolous complaint that was perjurously filed with a false narrative is not in the best interest of justice. In fact, the plaintiff's entire complaint is an impedance to justice. Your Honor. Your Honor. We've moved on to like, I'm rubber and you're glue. The plaintiff in a civil lawsuit has the burden to prove by a preponderance of the evidence. The burden of proof for a defamation case also rests on the plaintiff. Okay, we're now repeating ourselves. Therefore, it is still legally presumed that the statements the TikToker made are substantially true. No. Gouliard has not acted in a bad state of mind. I didn't know bad state of mind was the standard here, but tell me more. The plaintiff errs in arguing that Gouliard has acted negligently or in a bad state of mind by posting videos about her beliefs regarding the litigation since the beginning of the complaint. Unless proven to be defamatory, Gouliard's statements regarding the murders and subsequent discussions about the complaint are protected by the First Amendment. Okay. TikToker's right to freedom of speech is not suddenly revoked due to the filing of a complaint. The plaintiff's argument that she can prove Gouliard acted oppressively, fraudulently, wantonly, maliciously, or outrageously can establish that TikToker committed a bad act with a bad state of mind because TikToker relied on her intuitive abilities instead of evidence is weak. Your Honor, they're saying that I acted on my intuitive abilities and not evidence. That's a weak argument. It's not a weak argument. Gouliard is protected by the First Amendment of the United States Constitution to believe in faith-based practices. Ma'am, you can believe whatever you like. Defamation's separate from that. The plaintiff again erred in her argument that Gouliard acted maliciously by posting her ideas about Schofield's role in the murders after Brian Kohberger was arrested for the murder of the 4 students. Unlike Schofield in this civil case, Kohberger is fighting is criminal charges. He is presumed to be innocent until proven guilty. Notwithstanding the fact that Gouliard used clairvoyance to discern the truth of Kohberger's role and lack thereof in the murders, the evidence that Moscow PD detailed in the probable cause affidavit is weak. Gouliard is not required to believe the police's account of the events, that Kohberger, with no apparent motive, brutally stabbed the 4 students multiple times within 16 minutes, minus the time it takes to get in and out of his vehicle, somehow left with an exposed murder weapon due to the sheath being left behind with blood and DNA on it, yet left no trace of blood in his vehicle or on his person, walked directly past a witness without doing anything to her, despite being there just to kill for alleged research, left without any harm to himself, and somehow murdered Xana and Ethan first, but left while she or someone heard crying in Xana's room. What? Okay. The two things are not related at all. As stated by the plaintiff, Moscow Police Department did not yet believe my ideas regarding Schofield's role in the murders. Just the same, I do not believe in their illogical account of events. Your Honor, Moscow police don't believe me, and I don't believe them. What? She just keeps digging. She just keeps digging. The Fifth Amendment of the United States Constitution guarantees citizens that no one shall be deprived life, property, or liberty without due process of law. What does due process have to do with this? The 14th Amendment applies this principle to states in the United States. Thank you for the history lesson. In the case of criminal arrest and charges, the civil thing to do is to presume the citizen charged is innocent until proven guilty. No. It's not the civil thing to do. Within the criminal justice system, there is a presumption of Innocence, what does that have to do with this? Civility does not amount to malice or negligence. Oh, she's trying to argue that because she presumes Brian Kohberger innocent, she's not being malicious as to believing this defendant committed the murders. Okay. Lastly, in docket 64, plaintiff argues, no quotations, quote, we think, Ms. Gouliard alleged that Professor Schofield has photographs, videos, and messages from the night of the murder and during the murder on a collaborative book literature app she used to collaborate with the people that she had help her plan and execute the murders. Attorney declaration. TikToker claims in the video that anyone can get the photographs, videos, and messages from Schofield by issuing a subpoena to her, but Ms. Gouliard did not even do so in this case. It goes on to say the plaintiff errs yet again. Intuitive tarot readings require logical discernment to understand the applicability of the message. TikToker discerned from the intuitive tarot readings that evidence can be found in a collaborative book literature app. Anyone want to tell me what the fuck that is? And I have a question. That has photos, videos, messages, and is collaborative. It's collaborative. It's collaborative. Y'all, it's collaborative. That explains it. Gouliard then attributed that message to be either a literal collaborative book application or Facebook, a collaborative app that people use to send messages, videos, and photographs. To test that idea, TikToker served a subpoena to Meta Platforms. The plaintiff filed a motion to quash the subpoena. The court granted the motion to quash the subpoena. The plaintiff fails to present a valid bad act argument against defendant. The motion for leave to amend the complaint to add punitive damages must fail. No. Conclusion. For the reasons stated herein, TikToker's intuitive ideas that the professor hired men to murder and ensure the murder of the 4 university students is presumed to be legally true. No. The intuitive idea that the professor had an affair with one of the victims is presumed legally true. No. She then quotes New York Times versus Sullivan again and says, past the end of discovery, the plaintiff has not provided clear and convincing evidence that the statements Gouliard made are false. Considering the plaintiff does not intend or desire to go to trial for the merits of the complaint, it is logical to conclude that she put her best case together. Her evidence includes a declaration from Schofield, admissions from Gouliard that does not add value to her case, and TikTok videos of Gouliard posting content that has not proven to be false. It simply isn't enough evidence to prove her defamation case by a preponderance of the evidence. It is, though. The plaintiff has not proven her case. Therefore, a legally presumed murderer does not get to sue a whistleblower for punitive damages. Okay. The plaintiff's motion to amend the complaint must be denied. She's asking for sanctions again. There's more exhibits. Oh, this is the tip line from Gmail. The killers and the motive for University of Idaho students. Ash is God. To the tip line. And then this lays out exactly what she said before. Look, I don't think we would get to a defamation case if this stayed at being sent to the tip line. I don't think we would get here. If this stayed just being communicated to the tip line, we might not be here. But that's her tip to the tip line on Saturday, December 10th at 3:54 a.m. Apparently, Jack's motive was an opportunity to play tennis without the pressure of adult responsibilities. Yeah, nope. So, she's claiming whistleblower protections. She just keeps using words to try to mean things. These motions hurt my head. I can't imagine being the attorneys trying to argue against this, because it is so frustratingly circular, and they can't just reply with, excuse me, Your Honor, no. Like, no. All, no. Nope, no. Nope, nuh-uh. You have to respond. Maybe they don't reply. Maybe they just let it stand. Though they've tended to reply in the past. When was this filed? February 2nd. So they would be close in time to needing to respond. The replies are due at the end of this week. So we'll see if there's a reply at the end of this week. I'm ready for this issue to go to oral argument. I would really love to hear oral argument on the motion for summary judgment. Your Honor, just post this for oral argument. The judge is going to ask again, so what objective evidence do you have beyond your own belief that things are true? That these things are true. This is a mess. I feel for the professor. This isn't going away. And the judge has to just be like, okay, we're going to just go through this in a linear fashion and make the rulings we have to make. I think the judge might actually find liability here and grant the summary judgment motion. There's grounds to do it. And the judge has given more than ample leeway and opportunity here for this pro se defendant. I'm ready for oral argument. Let's set that for March sometime, Your Honor. That would be great. I really want to see the ruling on this motion for summary judgment. So I'm not done with this case. I feel like that maybe it's not the one that everybody's invested in, but like those of us that are invested, I'm so invested. I need to know what happens at the end. I need this case to be resolved. It's wild and it's not going away. I think of all the cases we've explored, we have not explored civil litigation with pro per defendants in this way. And it really is incredibly frustrating when you see a plaintiff that has to go to court to fight to protect their reputation and their rights against somebody who's just like, no, I said what I said. Like, how do you, the logic is not on the same spectrum of logic. And I think the court saying no, that this doesn't count. Your belief in something, your subjective belief does not count as an objective fact. She's just going to turn around and say to the court, I mean, that's corrupt. So this fucking case, man, it's the audacity of it all. And it's interesting because we've now watched the TikToker like backtrack a bit to being like, it's substantially true. And these are my ideas. Like we're seeing the backpedaling, but I don't know how this is ever going to go away because you're not dealing with two people on the same level of perception of reality, I think is the problem. And it's frustrating. It's really, really frustrating to watch it play out because the lawyers still have to respond to this shit. And those responses were not actual responses grounded and founded in fact-based arguments. It's just emotion and opinion. And that's not what's going to win the day here. And the court of law is going to have to sort that out. And at some point, just shut it the fuck down and just be like, you know what? We're not doing, they're not going to get anything on punitive damages anyway. We might see the court yeet the punitive damages argument and just grant the summary judgment. I could absolutely see that happening. So with all of that, let's get to questions. It's just time to take a breath and get to questions. Emily, this was going to be a shorter stream and then it wasn't. Yep. I needed to cleanse the audacity. So first, if you do not have the Lawnerd app, make sure you download the Lawnerd app so I can let you know when we're streaming tomorrow. We're just going over a court hearing tomorrow in the Hannah Gutierrez Reed case. That case is getting ready for trial. And then when it goes to trial, hopefully there will be video feed from it. I need to go pull court documents. I didn't get to do that. I didn't get to do that last week. Sick. So we will, hopefully there's a court feed for it and we'll cover that, but we will cover tomorrow's hearing. What time's the live tomorrow? I need to go double check. That's why I need y'all to get the app. I need to go double check. My twerking llama is on the other side of the office. We can absolutely do a pickle cleanse before we get to some of the questions. I'm not going to get to all of them. I'm going to do my best. That was a whole trip. My brain hurts. The circular arguing is just like, but Your Honor, it's not true because I believe it's not true. Are we cleansed? Are we cleansed? I hope so. Good to see you, Megan B. Good to see so many of the member chats. Thank you for doing all the YouTube-y, likey, subscribe-y things. We're going to get back into more court coverage, which is going to be great. Debbie, thank you. I love breaking it down for y'all. My brain hurts after this one. I thought like, oh, this might be light. No, it wasn't. It was all the fallacies of argument in one document. And I'm like, the back of my brain hurts. Bougie Girl, did y'all see EDB on Hulu's documentary, The Housewife and The Hustler? I hope you did. I enjoyed it. So, and I have, you guys are welcome to go be like, I saw you, girl, on Instagram. I put up a reel on it, or on my YouTube short on the Shorts channel about it. You guys have been giving so much love to the Shorts channel. Thank you so much. The team kept the YouTube Shorts coming on the Quick Bits channel last week while I was sick, and I'm so appreciative of them for that. You should catch the Adam Montgomery case. The defense attorney is a clone of Elaine. Sounds just like her. I don't know that case. I mean, there's always cases going on. I definitely try to parse out which cases we're covering and make sure they don't coincide with travel. I've got a little travel at the end of this month, so we're doing our best. Jay Michael said, thank goodness for EDB today. So needed to take a break from writing papers. Totally cannot believe it's been 29 months. And happy birthday, little Baker. Thank you. Happy birthday, you guys. Thank you for all the birthday wishes for my little one. Can I have a belated 50th birthday wish born February 11th? Of course you can. Happy 50th birthday, Alaya. It's yay. I mean, you've been in this community like since the beginning of this community. So happy birthday. So let's see. Brandy, thank you for the gifted memberships. What a year. I can't believe it. Excited to see you guys too. Thank you for all the excited statements. Mini cat cam in the reflection in your glasses. Yes, these are not sunglasses. These are my Erlin lenses, but sometimes you get the cats over to the side because I've got the window open. So yes, mini cat cam. Hello from Cali, sipping my lattes. Also, when I look this way, it's normally where I have my screen. So sometimes you can see them down here. I normally keep the windows a little bit covered up, but now with the bird feeder, it's fun to just be able to watch them. Happy Valentine's Day Eve. We're definitely going to all be together tomorrow for Valentine's Day. Here for a break from the Harmony Montgomery trial, which is a sad case for sure. Snow day in Rhode Island. Finally get to join a live instead of replay crew. Whoop, whoop. No school. Congratulations. When it started snowing last night, both my kids were like, so no school tomorrow? I'm like, look, y'all, you're getting way too comfortable living in Tennessee when there is 3 flakes of snow and there's no school. We had 6 days this year already of no school due to snow. No, you're going to school tomorrow. Arties, thank you so much. It is a great community. I love it. It's good to see you guys. Just logged off Diablo for TOU. Oh, okay. Thank you for the gifted memberships. Congrats. This is something to share. Law Nerds Rock. Isn't it fantastic? Thank you. Peggy Lamb, thank you. I'm not going to be jumping into new cases. I see you guys talking about it. I'm not going to be jumping into covering it. I'll go take a look at the lawyer, but I'm not going to cover it. I've already added Snoop Dogg's lawsuit against Walmart to the docket. We need a food court coming up soon. But yes, I have. We've got, there's stuff going on with Reese's. We need to pull up the one on Stanley. There's a couple. How would a lawyer handle a client with such outrageous legal concepts as the TikToker? I can't see her cooperating with the reality of legal advice. It's not easy. when people's mind is set in a certain direction and they won't listen to your advice. I don't know how she would find a attorney that would be able to do that. Did you hear about the new charges brought against the defendant who attacked the Vegas judge? No. If they happened in the last couple days, no, I did not. Almost 4 months working as an accountant. Congratulations, Angel. Good work for those who like to do it. I always appreciate it. So what happened with Snoop Dogg and Walmart? It's over cereal. So there's a whole bunch of lawsuits that I've got on the radar. It's just when we're going to get to them. Bella Bratt said, so if they yeet the punitive damages, what's to stop her from still stating these defamatory statements? What is the deterrent? They can still do damages, not punitive damages, but damages. And there will be some monetary harm, but what's to stop her? Even if, and I hate saying this, but this is the reality of the situation, so we just need to talk about it. Even if they get punitive damages, even if they get the compensatory damages and the rest of it, and attorney's fees and what have you, trying to recover it, I imagine we're going to see the TikToker just being like, I don't have anything. So what assets are you coming after? So there's just going to be a judgment out there that they're going to then have to spend the money chasing. There's not going to be a ton of deterrent here. And that's very frustrating. So can there be an injunction that has monetary damages if you say those things? We saw that in the Cardi B case. Maybe there can be an injunction saying you can't say these things. So we'll see. RK, every time you say TikToker's name, I think Julia Gulia from Wedding Singer. Wedding Singer is so good. Motion to refer to TikToker as Trelawney. I don't think that's fair to Trelawney. Trelawney was right a couple of times. Have you heard about the VTuber ongoing lawsuit? No, I have not. Angie said, so BK isn't guilty until proven guilty, but Professor is guilty because TikToker's intuition is right. Angie, I think you've summarized that better than I could. That's what she's arguing. Casey Cat said, just nope. That's a hard nope. It's all a hard nope. Can you cover the Bachelor false pregnancy lawsuit? I haven't seen that one either. So I will take a look. Candor and Moxie said, Emily, I was just diagnosed with ADHD last week. Congratulations. Thank you again for being so open about your ADHD. So much of my experience makes sense now. There is something very helpful just being told, hey, your brain works like this. Very, very, very helpful. It helps you put context around things, and it helps you explain to people, oh, hey, my brain works like this. And sometimes that's really helpful to be like, yeah, my brain isn't going to do that well. This whole response should earn Psychic Barbie a pretty white hug jacket. I think that there is a willful defiance going on with the TikToker. Per the CIA reading room, a fun place to read declassified documents. Yes, this is a real doc. I think they transposed creation and release dates. I think the creation was June 17th, 1998, release 2016. It possibly. It looks older than 2000s. Steven said my Botox is working overtime, trying to keep your face from facing. Question, is TikToker using the same ChatGPT agent to fill out her filings as the lawyer that got in trouble? I don't know. There's actual case law cited in there. TikToker is trying to say, essentially, truth is an absolute defense, and I believe what I said. And therefore it's true. That's not going to fly without independent evidence, but that's the argument she is trying to make, and she's trying to find support for that argument and is not going to find a lot of support for that argument. It's just very frustrating. So can this be thrown out then? No, Sue. It has to go through the process because the plaintiff has the right to have this go through the legal process, and they are going through the legal process. That's why they made the motion for summary judgment. The plaintiff who brought it has the right to go through legal process. The counterclaims are all thrown out. All the counterclaims that TikToker tried to bring, those are all yeeted by the court. But there's not much they can do. They chose to sue, and I don't think they had really any other choice. So, Judy, you got this, says TikTok lady is the pigeon on the chessboard. It's a mess. It really is a mess. Can the professor use TikToker's response as an exhibit to further prove defamation? I mean, they can use it to further prove the admissions. So, you know. Oh, Sweetie No said the first excerpt I found from one of her books references the science of getting rich. So her pearl clutching about money, monetary gain is amusing. I mean, she really does seem very, very pressed about the monetary gain. Stanley released new purples today, plum and lilac, delightful, but they're getting ready to release like a black and oil slick that has been leaking online. And that's, my eyes are on that. The black with the oil slick. It's like, it looks like it was made for me. So I'm going to have to figure that out. But that's being released in a few days. This woodpecker is just like loving the outside of my window today. Question, missed you much. Real question. What's the hoodie? This hoodie is one of my comfort hoodies. It is an Old Smoky whiskey hoodie. And it is super comfy. I have tried to find this type of hoodie. Oh, the color, yes, the chroma. The chroma looks amazing. So if you guys haven't seen the Stanley Chroma, it's like me in a cup. I love it so much. Your mom said, so glad you're back this week. I'm glad I'm back too. You guys, I am going to, it has been like 3 hours. I have got to go. It is time. We are definitely trying to do this on the 15th before I stream. I will be back tomorrow. Lawnerd app, I will tell you where. I will also try to populate the stream in just a little bit so that you guys have a heads up of when I'm streaming tomorrow for the hearing in the for who are we covering tomorrow? Hannah Gutierrez Reed. I think the last pretrial hearing. We'll do that. Katie said you were highlighted the ABC Hulu Housewife and Hustler doc. I was excited and proud. Thank you for real professional all the ways. You are the best. I sat down and did that interview with them in December. I was very excited to do it. So it was really a lot of fun. All right. So tomorrow I will see you guys in court. Let's see. I've got a message. Let me check this message real quick. Since the Lawnards were asking, I reached out to producers to see if there's any way for the international crew to watch Housewife and The Hustler 2. Right now, there isn't an official way without the Lawnards getting creative. It might come out later on another platform like Stars. ABC is grateful to the Lawnards for pushing it to #1. I didn't realize Housewife and The Hustler was now at #1. Thank you, Lawnards. We will find a way. I wonder if the producers would let me do a viewing party of it without striking me on YouTube. I'm going to go with that's probably a no, but why not? We can ask. Why not just ask for stuff? We'll ask and see what we can do. Like, hey, ABC, can we do a Lawnard viewing party? But with all of that, it's out on Hulu now. I will populate tomorrow's stream. I will see you back here tomorrow. Lawnards, you're the best. Take care. Happy Valentine's Day tomorrow, and I will see you tomorrow. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Lawnerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Lawnerd.